Sorry for the short delay. I was just editing the yesterday's one of the judgment. Yes.
My lord, I plead for adjournment, item number 17.
Item number 17.
Yes, one.
You are a CBI counsel.
No, no,
I am
no,
for
no.
the CBI.
So you are for the respondent.
Respondent 1 and 2.
Any objection? This is a quashing petition filed by the CBI.
Lordship, we are ready, but they need some time.
Are you objecting to the adjournment?
No, Your Lord.
Your name?
Pompa Chaudhary.
As prayed for by MSP Chaudhary, learned counsel, appearing for the respondent numbers 1 and 2, which is not objected by the respondent CBI counsel, relist on such and such date. Yes.
Yeah, please, Your
May I
Lord.
please, Your Lordship, my lord?
Yes, Mr. Kamal.
Regards item number 9, my lord. Well, actually, I'm speaking a short, taking the consent of the senior as well as the. junior
As
counsel.
prayed for by Mr. Jet Kamar, learned senior counsel, assisted by Mr. Dev Chaudhary, B, na? P. Dev Chaudhary, learned
That is.
counsel for the petitioner, which is not objected by Mr. MS Hussain,
Hussain.
learned counsel, appearing for the respondent, relist, yes, where?
Respondent number 2, my lord, respondent number.
Respondent number 2, relist on?
On 2nd of December, my lord. Tuesday, man. Much obliged.
Deeply obliged. Yeah, please, Your Lord. So, item number 7, item number 5, man.
Yes,
Can this matter taken after 2 weeks, my lord?
as prayed for by Mr.
D. Bora.
Huh?
D. Bora.
D. Bora, learned counsel, appearing for the appellant, which is not opposed by the APP MS so relist on such and such date. Yes.
May I please, Your Lordship? Also, with regard to item number 6 and 7, my lord, we have newly engaged, my lord. My lord, we are required to file Wakalatnama, my lord. Sometime.
You have been newly engaged for whom?
For the appellant, my lord.
Your name?
A. Gayan.
Mr. A.
Gayan.
Your Gayan?
Yes.
Mr. A. Gayan, learned counsel, submits that his office has been newly engaged to represent the appellant in the present criminal appeals,
Yes.
and accordingly seeks a short accommodation to put the power on record. Prayer is not opposed by the other side. Other side is there. You have taken
States-
consent.
My lord, we couldn't be able to contact, my lord.
Inform. You are there.
Yeah, I want more correspondent number 2.
You inform them. Let the relist on such and such date. Needless to be clarified, if power is not filed by the next date of listing, the matter shall indeed be proceeded in accordance with law. You file it if you want to file it.
May I please, Your Lordship? Regarding item 16, my lord, I have taken consent, my lord.
Yes.
But it may be taken, my lord, after 4 weeks, my lord.
The whole matter
For matter, my lord, compromise is going on, my lord. As
paid for by
committee,
Mr.
R. Ali, my lord.
R. Ali, learned counsel, appearing for the petitioner with consent from the other side, relist on such and such date. Yes,
On behalf of A alone.
in the same matter.
Lordship, for respondent.
Which is not opposed by Mr. A. Alam, learned counsel, appearing for the respondent number 1.
Please, Lordship, I beg to mention a matter for listing. Lordship, it was last
Listing?
listed on 10/2/2025. Kindly fix the matter for date.
You have to make an appropriate mention before the court, not before this court.
Obliged, sir.
Check with the court master, ma'am. You check with the court master, he'll inform you what is to be done.
For admission, item number 8 in supplementary list.
Yes, Mr. Roy, Mr. Datta. I think today it is there for the reply part, na?
Yes. No, my lord, I will enlighten your lordships in regard.
Some written argument was given by you? No,
I have prepared it.
or not
Told me to
given.
prepare. No.
Because I was trying to locate it in the file. I had a feeling you had given.
Last
So-
date only, Lordship, you told me to prepare.
Okay. So you are
So I
prepared.
will submit it.
Yes. We'd like to finish the hearing and if possible to dictate the judgment in court today. So make it short, whatever you have to do it. Yes.
My lord, some decision on the power of the reporting officer and the review officer in regard to the
Here the pass mark was 60.
40. 40.
No, he got 60, he got 59.
Oh, yes, sorry. 50, 60, he got 59.
And this pass mark is for what?
That's
What-
the eligibility criteria.
No, if, since I have to author the judgment, exact word would be what? This is
Is the
the
minimum benchmark, Lordship.
minimum benchmark. Minimum benchmark for eligibility for promotion is 60.
60.
660.
And after assessing the reporting authority's marks, the reviewing authority had given you 59. And he,
Given 59.
no, that appears only one person has given the marking.
No.
So I was trying to, no, and that is why I just want that clarification.
Yes.
It appears like 59 is given by the reviewing. Just let us
Review
be clear.
authority has concurred.
I also thought so, but let's have a look
Lordship,
again.
Can kindly go to page 49.
এটা এসিটো অকমান দিব পিছত বন্ধ কৰি দিব 40 অলপ কমাই দিব নোৱাৰে নেকি নাই নাই তেওঁলোকক কওক এইটো 25 মানত দিয়ক বা 26 ত দিয়ক
That system they don't have.
it's very difficult
Very difficult.
because you see you might sit for some time and go.
Yes.
I have to be sitting here till it's very difficult. After some point, we feel frozen. At some right now, I'm feeling suffocated because I was trying to
Right.
finish some judgment and come because I was getting late. So I was quickly trying to finish it. Now when I'm sitting here, I'm suddenly feeling suffocated because everything is closed here. Very, very difficult. They should. I was told in some.
When I feel, I can go.
You can go out. I don't have that luxury.
And I've been suffering, my lord, I'm aiming to be fit.
No, but see, that is another thing. If you are suffering from some, because right now everybody is down the weather.
Right.
So now, the moment you walk into such an environment, you might again
Yes.
that gets triggered.
Right.
It's very unhygienic. I don't know why.
In fact, is it dangerous for us because we.
Yes, keep going out and coming. I do not understand. Several times I have told the registry, well, why can't they have these independent control
Yes.
system in the courtrooms?
While
What is that difficulty? Why should the judges and the lawyers be subjected to such unhygienic condition, unhealthy condition? I do not understand. It's very strange. I think Mr. Mohanto, Mr. Datta, you should also take this matter with the registry from their bar side also. We've been saying it. It's very unfortunate that they are not trying to find out a solution for it. By simply saying their control is somewhere up will not do. It has to be in the courtrooms, no? In other places, I'm aware that, even if a central condition is there, individual in the rooms, there is a control panel. Correct. Why can't they do this? Every time we have to call them. Absolutely. No, off and on they can do. So what happened is that the moment we feel cold, they will switch it off. Then after some time, it becomes suffocating. Then again, there is no regulator. That control panel for regulating is not installed in the rooms. This is why the difficulty. Anyway, page
49 and 51, Lordship.
49 and
51.
yeah, kindly see here. If you see at 53, there are two columns, right? One is saying reporting authority, then reviewing authority. Then both reporting authority, reviewing authority signature is there. Then it says compilation of weights, right? Now here I can see only the signature of the reviewing authority. That is why, and then you say remarks of the reviewing authority in case of disagreement with reporting authority. Now, who has given this marking, the 59?
Authority, Lordship, reporting of authority signature is in page number 53. You can find it in page number 53.
I have 53. Reporting authority signature is on top, right?
in the left
Yes,
hand
Lord.
side, your lordship.
On the top.
No,
reference.
it's somewhat in the middle part.
Correct, but after that comes the next column. See, there both signature are there, reporting as well as reviewing, left and right, right? Then it says compilation of weights.
Yes.
Then the signature is only of reviewing. That's why I'm asking this, ultimately this 59 has been given by, my understanding is that at the end, after overall assessment, it is the reviewing authority who gave this 59. Perhaps because you see, all the other independent marks have been given by the reporting, which the reviewing has agreed.
Agreed.
Everything is agreed. Now, here it is a compilation of the weights. Key responsibility areas 32, managerial dimensions 24, outstanding performance 3, total weights 59. And accordingly, the total is given is 59.
Lordship, this part is the summary of the marks given earlier. This key responsibility area. managerial
If you
dimension-
both are saying that this mark is at the end given by the reporting, concurred by the reviewing, I will say so. But for that purpose, I was just asking that clarification. Is it like that?
Marks are given by reporting authority and reviewing authority has simply concurred.
Okay,
It is, I think it is so.
okay, fine. No, there was a small clarification required, so I don't want anything, error to go in the judgment. So that
Yeah.
is why I wanted this clarification. Because he could have, the reporting authority, reviewing authority could have disagreed.
Yeah.
In case of any disagreement, he could have given his comments.
It was open to him.
It was open to him. Okay. Now you wanted to show some decisions on reviewing.
Yes. Lord, I will take your lordship's judgment of the press court.
This is the apex court.
Yes,
What does it say?
at paragraph 11, your lordship. kindly.
This is on reporting authority. Mr.
Uh,
Datta, this is on reporting.
No, my lord, it is the marks given by the selection committee, whether it can be interfered by the court.
By the?
tribunal or- By the, interfered by the tribunal or by the court. At paragraph 11, your lordship will find. It is also, the lordship got that,
Yes.
para 11 at page 11.
Yes, please.
I'll give you that. It is also
Mr. Roy, you
contended
take
that
a seat.
that the marking given by the selection committee was arbitrary. The grievance was that the confidential report of Sri so-and-so for the year so-and-so was not available, and in case of Sri R. Parampriya, the confidential report for the year so-and-so was not available. Yet the reports of Sri Dayashankar was assessed to be outstanding, and Sri R. Ramapriya was assessed to be very good, without there being any basis for it. This was found by the tribunal to be patently arbitrary. It is the selection process and what prevailed with the committee after review of the annual confidential reports of all these officers cannot be dilated in writing. When the selection committee sits and considers the candidature of both the officers, and in case of both the officers looking at the 5-year annual confidential reports, one is found to be overall outstanding and the other is found to be overall very good. These marking of the selection committee cannot be interfered with the extraordinary jurisdiction or even by the tribunal. We fail to understand how the tribunal can sit as an appellate authority to call for the personnel records and constitute selection committees to undertake this exercise. The power is not given to the tribunal, and it should be clearly understood that the assessment of the selection committee is not subject to appeal, either before the tribunal or by the courts. One has to give credit to the selection committee for making their assessment, and it is not subject to appeal. Taking the overall view of the essays of the candidates, one may be held to be very good, another may be held to be good. If this type of interference is permitted, then it would virtually amount that the tribunals and the high courts started sitting on a selection committee or act as an appellate authority over the selection.
But
Not-
here it is the selection committee's market, but the case in hand is not selection.
But somewhat, my lord.
No, no, you
in
see,
regard to
in
the-
order to bring that analogy, you
Yes.
see, obviously, these courts are not exercising appellate jurisdiction over a selection process. But we are now examining the decision-making process
Yes,
of the APAR,
right.
correct? The
Right.
appraisal reports. Now here, these are discretions given to you. This is not some written examination.
Yes,
You have been given the right of the report because that is the reporting authority who is the best person
Yes, yes.
to judge that person.
wherever
as-
he's the only person.
Correct, as regards his, performance and
Yes.
everything. Now, based on that, he gives a marking. He gives his comments. The reporting authority's job is to see that the reviewing authority has fairly done his part. He is bound by the remarks. After seeing the remarks, the comment, the marks, reporting authority is not a postman that he will merely communicate it or he will just endorse it by a stamp.
Yes.
It is some exercise of discretion is given at his end as well.
Yes,
Now, in a given a situation like this, where the comments are not negative, you see, the comments are not negative
not
as
negative.
such.
yes,
In fact, it says very good. Quality performance, it says very good.
yes.
But out of 20 given 13. That is because at certain levels, there were some challenges. In his self-appraisal, he agrees. He admits fairly that yes, I could have performed better. But in village level, these are the challenges, the impediment I face. And you also agree. Ultimately, the mark that you give is under good. Good is from, it is maximum is 70, right? And minimum is how much?
55.
55. It is 55 to 70. From the markings, it says only 59. Reporting authority could have always added +1. If he would have got that +1, he would have passed. He would have become eligible for promotion. I'm on that.
I
You
understand
see,
that.
ultimately, because of that +1, which power the reporting authority had.
What?
Otherwise, what is the reporting authority's job? It seems because they did not exercise that discretion, he did not get his promotion. And in subsequent assessment years, he have done fairly very well.
No, there is a difference, my lord.
Whatever be it,
My lord,
whatever be
I
it,
like
Mr.
this
Doctor,
question.
because you see, this is not like selection. The promotion comes with certain benefits. At the end of the day, because of that one marking, I could have understood that the pass mark is 71 and he got 70. Then the question doesn't come because he comes under the category good. Good has been ticked. But what is the marking?
No,
for
here,
good.
my lord, I'll try to
You see-
justify that.
You see, that reporting authority definitely has some role to play.
And reporting
Because these
authority-
things comes to us in our administrative functions as well.
My lord,
We see at times we have to exercise our discretion for the larger interest also, right? So here, if it is good, what is wrong in giving a +1? I'm on that. Now, if this court feels that that is something unfair have been done, why not in 226 this court can correct that? Can always make that good.
My lord, I will explain.
Where is that shackles to the powers of this court under Article 226 of the Constitution of India? If
That-
this court comes to that finding that that has been, an illegality has been done,
No, arbitrariness and illegality.
so that is why I'm
That
saying,
will have to be proved.
correct. It is appearing
My lord,
that
there's a-
+1.
In that case.
Why +1 not given?
Is a question of evidence in that case. my lord.
What evidence? It is writ large, apparent on the facts of the case.
Anyway, my lord, regarding it.
I am only indicating my mind,
No,
Mr.
I-
Doctor, so that you can appropriately address the
Yes,
issue.
yes,
I shall give you full audience after this without interfering while you are submitting.
Mind.
But I am indicating the mind of the court. So this is what is going on. You see, because this is the 226 court.
Yes.
I understand the limitations. I'm not going to be reassessing or act as an appellate authority. But nonetheless, if it comes to the knowledge of this code that something has been done which needs to be corrected. Why not in 226 that can be done?
Exactly in this kind of scenario, my lord, the High Court gave B plus.
Hmm?
B plus, I mean marking. Then the Supreme Court has said the High Court cannot do that because it is the prerogative of the full court.
No, need not, High Court need not, I mean, this court need not give that +1, but can be sent back for the reporting authority to exercise that power once again, and then thereafter give the consequential benefit as it follows.
If the record
wha-
supports in that.
Yes,
case.
why not that can be done? That exercise, where is the bar for doing that exercise?
But
This court
even-
can always send the matter back to the reporting authority to reassess and fairly do, and thereafter whatever follows from that marking, whatever notional benefits are as will follow, he shall get it, and we can fix a time frame. Where is the bar for doing that?
In that case, my lord, the benefit in the sense, notional benefit in.
course he will get it. Of course, he'll get.
Benefit of promotional skill, I don't think after retirement anybody can ask for that.
No, whatever he was deprived.
That notional, I mean, benefit.
Because
that-
if ultimately
in
the
sense-
reporting authority find that yes, +1 should have been given. Then the moment he gets +1, he comes under the zone of consideration, and if at that time he has been and getting into there, if he was deprived, he has been deprived of his legitimate promotion, then that benefits notional has to be given.
Notional, of course.
Of course.
That is.
I am saying notional. How can we give him the promotion after he's retired?
Right.
I don't think he's claiming that
that
also.
is already-
He knows his limitations. He knows
Appeals
where he
court has
stands.
set at rest that point.
Huh?
Appeals court has set at rest, what will be the consequence?
Correct. So whatever in accordance with law, he will get.
Yes, but then, my lord, first you'll have to cross the hurdle.
Okay. Now you can
Now, my lord, I have to
address.
take your lordships to another decision of the appeals court. 1997, 4 SCC, page 7.
The other day you had given one Rajendra Singh
Yes,
Verma.
I'll take your lordship to that. also.
What was that?
That, my lord.
147, I think. What was
One-
that?
I'll.
Just give me, I'll just write it down. What was that for?
That is a 2011 10 SCC.
No, I have the photocopy. What was
Paragraph, my
that?
lord, 147.
Yes, what, on which point?
That is the exactly which we are on, my lord. At 147, I will take your lordship.
Yes, let's see.
Paragraph 147.
Yes.
Writing the confidential report is primarily and essentially an administrative function. Normally, tribunal courts are loath to interfere in cases of complaints against adverse remarks and to substitute their own judgment for that of the reporting or reviewing officers. It is because these officers alone are best suited to judge the qualities of officials working under them and about their competence in the performance of official duties entrusted to them. Despite fear of abuse of power by prejudiced superior officers in certain cases, the service record contained in the confidential report by and large reflects the real personality of the officer. Then, my lord, your lordship may see paragraph 186.
Paragraph?
186.
1 second. Well, let's see 150.
150. This court has consistently taken the view that an order of compulsory retirement is not a punishment and does not have adverse consequence, and therefore the principles of natural justice are not attractive. What is relevant to notice that this court has held that an uncommunicated adverse issue on record can be taken into consideration, and an order of compulsory retirement cannot be set aside only for the reason that such uncommunicated adverse entry was taken into consideration. If that be so, the fact that the adverse issue was communicated, but none of the appellants had an opportunity to represent against the same, before the same was taken into consideration for passing the order of compulsory retirement cannot at all vitiate the order of compulsory retirement.
Yes, which paragraph?
Now, my lord, I will take your lordship that
No, I just finished reading 151. After that, you wanted another paragraph, no?
186.
What is that? One?
186, my lord, at page 75, your lordship will find. I'll read from to summarize, it is held from there.
Yes.
The adverse remarks recorded by the High Court in the confidential report, it's a case of a judicial officer. The adverse remarks recorded by the High Court in the confidential reports of respondent number 1 for the year 1994 and 95 were not without any material. They were recorded on the basis of material on record.
You see, here, first of all, there is no adverse remark.
Yes.
There's no adverse remark. Quality of performance, very good. I'm also on that. It is not, you see, nobody would have been prejudiced if that 1 mark was given to him. That is why on the last occasion, I clearly adjourned this matter to find out the role ambit of the reporting authority. He's not a postman.
Report.
On that, I wanted some
Yes.
assistance from you both. What is the role of the reporting authority?
Certain decision I'll.
You place that.
Madam
Because
Chair,
I'm on that.
let
You
me-
see, certainly the reporting authority is giving an adverse mark. How can the reporting who doesn't even know can comment, or how the courts can comment on that? Unless and of course something very mala fide is alleged against that reporting authority, then it's a different thing. But here that is not the
They
question.
have alleged the malafide, but then. it's not a
Whatever,
part.
we are not on that. We see sometimes matters has to be also seen from a practical, emphatically angle as well. It is nobody's case that he has underperformed. It is nobody's case
Yes,
that
yes.
he's not being able to do his job.
No, it's not the.
On the contrary, it is your case that his quality of performance is very good. But out of 13, you have given him 8. 6.
In managerial dimension, out of 8, 3.
No,
37.
in that
In quality of performance, 13 out of 20.
correct. 13 out of 20, 13.
It's a very good mark.
Not very good, Mark.
After
You see,
13
that
is-
13 has been given because it felt that at certain level at the grassroots, some penetration is required.
Yes.
But he has given those reasons. Why at village level difficult for disposals? Because scope of disposal is less compared to semi-urban areas.
Anyway, my lord.
So that is where the performance, so this could have been considered. I am only on a human angle to the whole thing. Nothing else. Yes.
That, my lord, that question of
But
1 mark.
so what is the reporting authority's job?
At least, my lord, let me finish this paragraph. my
Yes,
lord.
please.
Then, my lord, B, your lordship will find. The learned single judge should not and could not have graded B plus to respondent number 1, as it is the function of the High Court to assign appropriate grading. High Court in the sense, my lord, the full court. Therefore,
So
the
this
matter.
is what I'm saying I will do. This part I'm saying I'm going to do.
No, no.
Where did I say ki I'm going to
No,
give
no,
him
no, I'm
plus
not-
1?
I'm not.
I'm saying I will do this.
Yes.
Therefore, the matter should have been referred to the full court for giving appropriate grading.
Right.
This direction of the learned single judge is accordingly
That's the
satisfied.
indication your lordship has given.
I have given that
That's,
indication. I am not saying I'm going to give plus
No,
1,
no, that is what.
but I will refer it to the reporting authority to grade him appropriately,
what I-
considering the quality performance assessed by the reporting
Right.
authority.
that is
very
what I'm
good.
Saying what in Rajendra Kumar case, what the lordships held, my lord, I'm just referring to.
Yeah.
Then, my lord, paragraph 190, 191. 190, your lordship kindly see, Roman 2. Making of an adverse entry is not equivalent to imposition of a penalty, which could necessitate an inquiry or giving of a reasonable opportunity of being heard. to the government servant. Then paragraph 191. Further, in case where the full court of the High Court recommends compulsory retirement of an officer, the High Court on the judicial side has to exercise great caution and circumspection in setting aside that order because it is a complement of all the judges of the High Court who go into the question. And it's possible that in all cases, evidence would not be forthcoming about integrity, doubtful of a judicial officer. Now, these are the certain things your lordship will find. Even in the ACR, when the confidential report is written, the many things will not be on record, my lord, the appeals court has said in 1997. I'll take your lordship to that also. So in that context, it is says, in regard to the integrity is doubtful. These are, my lord, the person under whom he works, only he is the best suited person who can say. None other than that, my lord, nobody can say that. Then paragraph 192. Normally, the adverse entry reflecting on the integrity would be based on formulations of impressions, which would be the result of multiple factors simultaneously playing in the mind. Though the perceptions may differ, in the very nature of things, there is a difficulty nearing an impossibility in subjecting the entries in the confidential rules to judicial review. Sometimes if the general reputation of an employee is not good, though there may not be any tangible material against him, he may be compulsorily retired in public interest. The duty conferred on the appropriate authority to consider the question of continuance of a judicial officer beyond a particular age as an absolute one. If that authority bona fide forms an opinion that the integrity of a particular officer is doubtful, the correctness of that opinion cannot be challenged before court. When such a constitutional function is exercised on the administrative side of the High Court, any judicial review thereon should be made only with great care and circumspection and must be confined strictly to the parameters set by court in several reported decisions. When the appropriate authority forms bona fide opinion that compulsory retirement of a judicial officer is in public interest, the Reed Court under Article 226 or the court under Article 32 would not interfere with the order. Then, my lord, your lordship, just last paragraph 218. At page 85. On a careful consideration of the entire material, it must be held that the evaluation made by the committee, full court, forming their unanimous opinion, is neither so arbitrary nor capricious, nor can be said to be so irrational so as to shock the conscience of this court to warrant or justify any interference. In cases of such assessment, evaluation, and formulation of opinions, a vast range of multiple factors play a vital and important role, and no one factor should be allowed to be blown out of proportion either to decry or defy an issue to be resolved or claimed, thought to be considered or resorted. In the very nature of things, it would be difficult, nearing almost an impossibility to subject such exercise undertaken by the full court to judicial review, except in an extraordinary case, when the court is convinced that some real injustice which ought not to have taken place has really happened, and not merely because there could be another possible view or someone has some grievance about the exercise undertaken by the committee, the whole court. Now, this is the last paragraph of this. Then now, my lord, the next decision, 1997 4 SCC, page 7, I have just handed over to your lordship.
Paragraphs?
Paragraph 7 and 8. I'll read paragraph 7.
Yes.
It does be clear that the object of writing the confidential reports and marking entries in the character rules is to give an opportunity to a public servant to improve excellence. Article 51A J enjoins upon every citizen the primary duty to constantly endeavor to prove excellence, individually and collectively as a member of the group. Given an opportunity, the individual employee strives to improve excellence, and thereby efficiency of administration will be augmented. The officer entrusted with the duty to write confidential report has a, this is the, my lord, the duty of the reporting officer. The officer entrusted with the duty to write confidential report has a public responsibility and trust to write the confidential report subjectively, fairly, and dispassionately.
I'm on that.
Yes, yes.
And a due diligence has to be also exercised.
Yes, I'm conscious of that. That's the
You
reason,
see,
my lord.
because the idea is to for improvement, not for depriving him. The moment he's got 59, he has been deprived for his next promotion. When there was nothing adverse,
Yes,
when there was nothing adverse, where is the fairness there? Where is the fairness?
of course, your lord.
Where is the fairness? Justice, the preamble, the
He-
first opening word. Where is the justice?
He has to cross the eligibility criteria.
No, you see, that is the job of the reporting authority that comes in. He could have given him that one, which he did not. There was no adverse remark. I am on that, Mr. Dutta. He could have easily done it. Otherwise, why do we need these reporting officers? They are all having a particular duty assigned to them. You are absolutely right when you say it is the reporting who knows what the best about the person. He has fairly assessed. While assessing it, because he was not conscious of the marking at the time of assessing him. So he gave the mark. At the end, this is how it came. Now the matter comes before the reviewing.
What
He
is working in my mind.
he immediately finds that yes, there is nothing adverse. However, he will be deprived of his promotion if 59 stays. That is by 1 mark. When it is the reporting authority who has assessed him as good, and good is 55 to 70. That is where the reviewing authority could have added the +1.
It was in the.
To be fair,
Yes.
to do proper justice. But that fairness was lacking. He did not bother. He could have exercised his powers diligently. He did not.
Power of the review authority, my lord. If you downgrade, then the question of reasoning and all this.
He is not downgrading it.
It is, he did not downgrade.
He is not
So
downgraded it.
therefore,
He's only concurred. But he
concurred.
has the power of adding also.
That is there, but then he thought possibly the marking was.
So that is why I'm saying diligent, fairness at that moment seemed to be lacking. Especially when there was nothing adverse recorded by the reporting authority.
Anyway, but let me come.
Yes, Mr. Datta.
My lord, your lordship has given us chance to argue the case in a full-fledged manner. And that way, my lord, we are enhancing our knowledge.
Yes, we don't know at the end what this court is going to also hold.
My lord, we are all discharging our duty. We don't have
Absolutely.
anything.
We all are learning every day.
And this is. the
And
position.
right now, Mr. Roy is also taking benefit of the exchanges going on in the court. He's also getting enhanced
Yes.
in the legal field, though he doesn't come from the legal
Right.
field. That's why I'm saying. Yes,
And this is the profession, my lord, learning never stops.
absolutely.
Though, my lord, I am reading once again. The officer entrusted with the duty to write confidential reports has a public responsibility and trust to write the confidential reports objectively, fairly, and dispassionately while giving as.
Of the reporting, na?
Yes.
Objectively,
The officer entrusted with the duty to write confidential reports has a public responsibility and trust to write the confidential reports objectively, fairly, and dispassionately.
dispassionate.
Yes. While giving as accurately as possible the statement of facts on all overall assessment of the performance of the subordinate officer. It should be founded upon facts and circumstances. Now, these 3 or 4 lines very important. Though sometimes it may not be part of the record, but the conduct, reputation, character require public knowledge or notoriety and maybe within his knowledge. Before forming an opinion to be adverse, the reporting officers writing confidentials should share the information which is not a part of the record with the officer concerned. Have the information confronted by the officer and then make it part of the records. These amounts to an opportunity given to the erring corrupt officer to correct
You
the
said
error.
this is important, but this is not part of.
This is not in his case, my lord. I'm reading for the purpose of this particular case, my lord. Now, what happens, certain things while the reporting officer write, always this may not be in the part of record. Because it's a knowledge gathered from the interaction.
It's all right, that is general, Mr. Datta, that is not applicable in this
Well,
case.
So therefore,
Nothing adverse is written here.
adverse is not there at all.
Whatever he has reported, he has fairly reported. There is no problem
It's
with
a very
the.
good outstanding.
Correct, there is absolutely no problem with the reporting authority from the court's point of view.
Right,
He may have a grievance against the reporting authority. The court is not have, the court doesn't find anything wrong as far as the report. He is objectively assessed it.
yes, yes.
While objectively assessing it and fairly assessing it, he is not conscious that he has to ultimately give more than 60 marks.
Yes, yes.
That is not his, that is not how a reporting authority will do it. He is doing it, and at the end, when he finds what has happened, has happened. Now comes the reviewing authority. I am only on the reviewing authority as far as you are concerned, because I am not going to agree with the petitioner if they are having some, because the reporting authority, I don't think has been arrayed here also in person.
No.
And there's nothing as such pleaded against the reporting authority as far as malice in facts is concerned. But it has to be pleaded, proved, right? Merely saying will not do. And if you are saying something, then you have to bring that officer on record. Otherwise, malafide cannot be proved.
Yes.
These are settled law.
Now, my lord, para 5, para 8, I'll be reading because the person against whom you are making some allegation, he must be your nominee.
He
Now,
must be
this
on.
case, my lord, your lordship, I'm reading this para 8, which is very important in this respect. It is seen from the record that the respondent constantly maintained a good record earlier to the adverse remarks made for the aforesaid period. It would appear that subsequently also he had good confidential reports on the basis of which the clouds over his conduct were cleared and he was given further promotion. Mr. Rakesh Dwivedi, learned additional advocate general, in fairness, therefore, stated that since the respondent has been regularized after the subsequent good reports, the dispute does not survive for adjudication on merits, but the counter comments made against him by the secretary were warranted in view of the material on record. He brought to a notice that as on the date when the entries were made, the vigilance inquiry was pending against the respondent and therefore the adverse remarks came to be made. The findings recorded by the Tribunal of Malice and arbitrariness on the part of the secretary as affirmed by the High Court are not warranted for two reasons. Firstly, when the secretary was not your nominee to the proceedings and had no opportunity to explain the position, it would be violative of the principle of natural justice. My lord, the Supreme Court has said, my lord, if you make some allegation against the particular person, you must make him a party, otherwise, my lord, it cannot be taken into consideration.
I've just said it.
Yes.
I've just said that, and you are now giving me a decision to the same effect. It's
Right.
all right. These are settled position.
Now, another decision my learned friend has cited, that is Ajit Kumar versus Union of India. My lord, from this, I'll take your losses to paragraph 25, which is said. But his argument was there. Your lordship, kindly see paragraph 25 at paragraph 25. I guess.
Yes.
Merely because the petitioner's APR for the previous year graded him as outstanding and very good cannot mean that for the relevant year based on his performance, it cannot be graded as good. Writing an APR is an annual exercise and depends on the performance of the officer in that particular year. it cannot be disbelieved or branded as arbitrary only because of the officer's prior grading. Now here, my lord, the court has said that merely because the earlier year your grading was very good or outstanding, the next year you cannot be graded as good. Now, in this particular, in banking parlance, your lordship will find a person is not static in the same post in all the time. Now, here your lordship has seen three, in this particular case. Your lordship has seen on 2010-11, his assessment as an officer, he was working in support role in the regional office. Now, in regional office, the regional manager was the next officer.
We are concerned with 10-11, na?
2010-11.
And in 11-12 he got 95.
11-12 is okay.
95 he got.
He was working in training center and his performance was based on the ability of
Okay.
imparting training and deliver lectures where he did well. Now, because of that, there he got 95 and because of that reason, the earlier year he got 59. Now, these, because these are the different status, my lord, he was working. Now, in other cases, like if he's an engineer, in all the 3 years, he might have been in the same status. So therefore, there, to some extent, my lord, this analogy may work. But in banking parlance, my lord, it's not all the same.
Training centers, the job, nature of job is for
Different.
training. Here, for the 10-11 he was where?
He was under regional office. He was
So there it was more dealing with clients and all,
yes.
more groundwork.
Groundwork, and he was his immediate boss was the regional officer. Under him, he worked.
And I
So-
think he was trying to get hold of the defaulters.
I had many responsibilities. But
Administrative
Lordship,
work.
one more point, if I'm allowed to speak here.
You'll have your turn, Mr. Roy.
Okay.
Now, in the banking, I mean the branch office, my lord, when he's a manager, in that case, what happens? There is a target is there. If you achieve this target, you will get these marks. So these are all, my lord, the fixed criteria are there.
That is why I see, you see, Mr. Datta, I'm agreeing with you on every front.
My lord.
It is you who have assessed him as good. What is the marking for good? What is the marking for good?
Marking has been given, your lordship.
What is it?
As page 49 and.
What is it? 55 to 70.
Yes. My lord, where to see?
I am on that. Because you see, I am aware of this, that as reviewing authorities, one could have easily made it +1 or 2. There is no bar.
That is. of
That
course,
is the domain of the reviewing authority. So you see, if the reviewing authority turn it from very good to very good, then he has to give a lot of reasoning.
Yes. yes.
He cannot simply, because he doesn't, he's removing, you see, he's totally overturning the comment on the marking given by the reporting, right? Here he is with the reporting, but being fair. He could have been fair. Fairness is the anesthesia of justice, isn't it?
Because of, my lord, 1 mark, the compassion, a little bit of that kind of thing comes up.
Not compassion, his whole promotionals, it got hampered.
That's true, but then.
His service prospects. The word I'm using is fair. That's why from the beginning, and justice.
That's true. I don't.
His whole
But-
service and that's not a case where there is an adverse rating. If it was an adverse grading, I would have not said it. It's not the domain of this court to go into that criteria.
Right. In that front, my lord, I'm with your lordship. So for that part
Yes.
is concerned, of course. Then, my lord, I'll take your lordship another decision. If I am not troubling your lordship.
No, wait, what are you troubling me for, Mr. Datta? I'm here to hear.
I remembered, my lord, I was arguing a service matter before the Honorable Justice Rishikesh Roy. And his lordship gave me all sorts of time and all that. Then possibly lose his coolness. He told Mr. Datta, you made your research, you want to show me all the decisions.
No, that
That's
is,
why
that
now
is,
he's a bit
no,
careful.
no, you see, Mr. Doctor, then what happens? If you see on the same point, if
Yes,
you,
it should
if
not be
you,
repeated.
you should not be multiplying the judgments
Right.
because one judgment is
One is-
sufficient for the point.
One is-
Unless you think your case to be very weak and you are being more defensive, then maybe 2-3. But we don't need 2-3 judgments for the same points.
Yes, it's not required.
It is not required.
Argument
It only delays the disposal.
Right.
And with all the now you see everybody is talking about early disposals, early hearings. So if you have to really, because it is not for the judge alone
Right.
to ensure an early disposal, it is a bar and bench. It's a combined effort. Now, how can you say if the bar burdens that with 10-15 judgments and leave us to give the judgment, it is obviously going to take time. You see, because we have to read those judgments. If you cite it, we just can't keep them besides and just give the judgment. We'll have to deal with it.
Accidentally, if I do that, you know.
No. You will not do it. I know it, Mr. Datta.
My lord, these statements I will take your lordship's paragraph 19 only.
Swapan Kumar.
Yes.
Yes. Limited role of interference.
Yes. In case of this nature, ordinarily the High Court would not exercise its discretionary jurisdiction under Article 226 of the Constitution for exercising the power of judicial review. The court is a limited role to play. Already your lordship has said that. It could interfere only if any legal error has been committed.
You're reading from which para?
Para 19,
Or 9?
the last page.
Yes.
These are 4 lines only.
Yes. No problem.
And this, in regard to eo nomini Milon, and another decision, if I like to multiply, Milon, that is 1992 supplementary 1 SCC. Page 222, paragraph 55. I'll not read you, I just giving it to your lordship. In regard to a criminal trial.
Yes.
Paragraph 55, your lordship.
Yes.
Then, my lord, another true decision, then I will stop. My lord, since Mr. Roy has retired, now what will the consequence, supposing if he is eligible also?
This is on that.
Yes, my lord, these 2 decision I am taking, your lordship.
No, this state of Bihar is on what?
That is, my lord, in regard to
Jurisdiction,
if
power.
you allege a malafide, in that case, unless you make a party, in paragraph 55.
Okay.
It is settled law that the person against whom malafide or bias was imputed should be implemented.
Okay. That is all right. Yes, the other next 2 judgments.
Then.
Give both together.
Yes, I have given both. Your lordship may see 2024 SCC online 1768. In paragraph 18.
Where is it? Two thousand
2024 SCC online Supreme Court
1768.
1768.
Paragraph.
Paragraph 18. Then 20.
Retired.
Yes.
Relief. Correct?
Yes.
Yes.
In para 18, it is no longer res integra that a promotion is effective from the date it is granted and not from the date when a vacancy occurs on the subject post or when the post itself is created. No doubt a right to be considered for promotion has been treated by courts not just as a statutory right but as a fundamental right. At the same time, there is no fundamental right to promotion itself. In this context, we may profitably cite a recent decision. Your Lordship may skip this. Then Your Lordship may see para 20. In state of Bihar versus so and so, it was held that retrospective seniority cannot be given to an employee from a date when he was not even born in the cadre, nor can seniority be given with retrospective effect, as that might adversely affect others. Then subpara 37, Your Lordship can see. We are also of the view that no retrospective promotion or seniority can be granted from a date when an employee has not even been born in the cadre, so as to adversely affect the direct recruits appointed validly in the meantime, as decided by the court, and so on, so and so. Then Your Lordship can see the next decision.
Yes.
Then 2024 SCC Online Supreme Court P512,
Yes.
paragraph.
So what can be given in that situation?
My lord, if your lordship hold that he is required to be given 1 mark more by the authority concerned, lordship may send it back to them to consider that. And if he gets that, in that case, he can get notional benefit in regard to his pensionary benefit. This much interest he may get. But then, so far, unless in this decision your lordship will find, if he doesn't work in the promoted post, he is not entitled to get that. And in regard to this law is settled since earlier.
Yes.
My lord, para 15, my lord, I'll read. The primary question that arises for our consideration in the present appeal is whether respondent number 1, who was recommended for the promotion before his retirement, but did not receive actual promotion to the higher post due to administrative delays, is entitled to notional financial benefits of the promotional post after his retirement. Then para 18 and 19. Upon a bare perusal of rules so and so of the West Bengal Service Rules, it is clear that promotion cannot be retrospectively granted after retirement, as it requires the actual assumption of duties and responsibilities of the promotional post. In the present case, since respondent number 1 superannuated before the final approval of the promotion, he could not have formally assumed the charge of the functional post of Chief Scientific Officer. Therefore, although respondent number 1 was recommended for promotion, rule so and so precludes him from getting the financial benefit of the promotional post without having taken on the responsibility of the said post, that is the Chief Scientific Officer. It is well settled principle that promotion becomes effective from the date it is granted, rather than from the date a vacancy arises or the post is created. While the courts have recognized the right to be considered for promotion as not only a statutory right, but also a fundamental right, there is no fundamental right to the promotion itself. In this regard, we may gainfully refer to the recent decision. That decision I have just read. Now, that's all, my lord, so far the entirety of the case is concerned. Now, even my lord, the decision cited by my learned friend, my lord, these
He has given one judgment, I think, Manoj Kumar, para 19. Oh no, there were few more judgments.
Abhijit Ghosh Dasti there. My lord, it was cited by Mr. Roy, there also your lordship will find
Which one?
Abhijit Ghosh Dasti, that is 2004. Oh, absolutely.
Judgment number 6, Lordship.
Judgment number 6, the last one.
Last one.
Yes. Para 4 and 5.
Yes. Learned counsel appearing for the appellant.
Read para 4 and 5.
Yes.
It is not in dispute.
It is not in dispute that the CAT Patna bench passed an order recommending the authority not to rely on the order of caution dated so and so and the order of adverse remarks dated so and so. In view of the said order, one obstacle relating to his promotion goes. Coming to the second aspect that though the benchmark very good is required for being considered from promotion, admittedly the entry of good was not communicated to the appellant. The entry of good should have been communicated to him as having very good in the previous year. In those circumstances, in our opinion, non-communication of entries in the SEL of a public servant, whether he is in civil, judicial, police, or any other service other than the armed forces, it has civil consequences because it may affect his chances for promotion or get other benefits. Hence, such non-communication would be arbitrary and as such violative of article so and so. The same view has been reiterated in the above referred decision relied on by the appellant. Therefore, the entry is good. If at all granted to the appellant, the same should not have been taken into consideration for being considered for promotion to a higher grade. The respondent has no case that the appellant had ever been informed of the nature of the grading given to him. Now, the counsel appearing for the appellant has pointed out that the officer who was immediately junior in service to the appellant was given promotion on so and so. Therefore, the appellant also be deemed to have been given promotion from so and so. Since the appellant had retired from service, we make it clear that he is not entitled to any pay or allowances for the period for which he had not worked in the higher administrative grade group A.
So
But
the same thing is given.
yes,
What you are saying, pension and retirement
Yes.
benefit, that's what he is saying, isn't it? Now, in your case, for 11 and 12, you have, for 10 and 11, you have got good. But the year before, what was it? For before 10 and 11?
Before 10, I was promoted, Lordship.
Huh?
I was promoted.
So what was the
Because-
grade?
That in those days, actually, Lordship, the policy was different. There was no requirement of any minimum APR marks. This
Oh, oh.
new requirement of APR marks was started from 2012 only. But it was started retrospectively. That created all the problems.
No, but in earlier APR, it was what? Good or very good? That you don't have. Because subsequently you have shown it is very good.
yes, sir, he has shown subsequently his.
I think that is on record. The subsequent you have got very good. In this
2000
case which you are relying, the previous year was very good. Thereafter it was good. Therefore, the court says ki now that it has good, the good affects his promotion chance, so it should have been communicated to him. Since it has not been given, admittedly it was not communicated to him, therefore that cannot be looked into. I think, Mr. Datta, that is how this decision, isn't it?
Yes, yes.
And that is why ultimately retrospective promotion has been given from the date which your junior had been given. But since you retired, only pension benefits. This is what I think is Avijit Ghosh Dastidar.
Correct.
Have I understood it correctly?
But there is a difference, Lordship.
Huh.
The difference is in case of Abhijit Ghosh Dasida, the court's observation was that Abhijit Ghosh Dasida did not assume responsibilities of higher post. That is why he is not eligible for the financial benefit. But in my case, it is not the same because in bank promotions are always given from the date of declaration of result. Even in this case also not.
That is different. But
And
you
moreover-
have not worked in the promotion post.
But Lordship, I have worked as a faculty,
No, that's all right,
With the
but
same
not the promotional post as such.
but then.
Anyway, that is the aspect. I'm not going to go into all that aspect, Mr. You can argue everything under the sky, but ultimately the court has to be conscious of what the court can give and not give, or what can be the scope of
Yes.
the adjudication. There is no bar for you. You can argue whatever you feel like under the sky. Yes.
That's all.
Mm. Yes, your reply.
Lordship. The first thing is that the seriousness of this adverse emotion understood. Lordship, I was not only disqualified for 1 year, in the next year also I was again disqualified for the same APR because next year they changed the policy. It was because one issue was raised the previous day by the London Senior Council that I did not appear further in the exam. In 2013 I applied. 2013 again I was disqualified for the same APR. I got 295, but zone of consideration was 3 years, 10, 11, 11, 12, 12, 13. So 11, 12, 12, 13 I got 95 each, but for this 59 again I was disqualified in 2013. In 2014 again I applied. I had 395 consecutively. I was called for interview, but I was not promoted. And then I got an understanding that unless and until this court case is withdrawn, I will not be promoted. So from then onwards, of course, it is true, I have not appeared for promotion any further. Now coming to some of the specific issues that has been raised by the Learned Senior Counsel, but before that, Lordship, I'll just like to submit before you one very important observation by the Honorable Supreme Court in Devdutt case. I'm also submitting that summary note also here, Lordship. Now, Lordship, two judgments and 2 copies are given there. Devdutt,
Yes, Devdutt.
I have given 2 copies or 1 copy, Lordship? So I have-
Devdutt only
I have the
one.
copy. Yes, Lordship, I have the copy.
One.
Lordship, kindly see page number 5, paragraph 10.
Yes.
In the present case, the benchmark, that is the essential requirement laid down by the authorities for promotion to the post of superintending engineer, was that the candidate should have very good entry for the last 5 years. Thus, in this situation, the good entry in fact is an adverse entry because it eliminates the candidate from being considered for promotion. Thus, nomenclature is not relevant. It is the effect which the entry is having which determines whether it is adverse entry or not. It is thus the rigors of the entry which is important, not the phraseology. The grant for a good entry is of no satisfaction to the incumbent if in fact makes him ineligible for promotion or has the adverse effect on his chances. This is exactly my case. They might have given me good, but because of getting 59, even in good also, some of the candidates from the good category also who got 60 and above, they were qualified. But because I was given less than 60, I was
I
disqualified.
am with you
So
on
for
that.
me, Lordship, 60 is also adverse. Now, Lordship, there is a judgment.
60.
60 is the qualifying mark.
Correct.
So anything
59
is
below,
anything
below
below
60.
60 is
Correct.
adverse.
Below 60.
Below 60 is adverse. So for me, 59 is also adverse.
What have been done in this then?
Now,
Since in our opinion, the good entry should have been communicated so and so. So in your case, it was not
It was not
communicated, admittedly not
it was
communicated.
admittedly not coming.
Uh,
Now, Lordship, the respondents have.
1 second, please read para 11. Why are you in a hurry, Mr. Roy? Huh?
I don't know, Lordship, how much time I will get.
Who's fixing the time for you? Has this court
At your
indicated?
mercy.
No, you're not. I'm here to hear your case. You should walk out of this courtroom fully satisfied that you've been properly heard. This is the system.
Yes, I'll be so obliged.
So unless and until you are fully satisfied, I shall not stop you. And I shall not even stop you. You will stop yourself when you are satisfied. Yes, face it. Yes.
Hence, in our opinion, the good entry should have been communicated to the appellant so as to enable him to make a representation praying that the said entry for the year 93-94 should be upgraded from good to very good. Of course, after considering such a representation, it was open to the authority concerned to reject the representation and confirm the good entry, though of course in a fair manner. But at least an opportunity of making such a representation should have been given to the appellant, and that would only have been possible had the appellant been communicated the good entry, which was not done in this case. Hence, we are of the opinion that the non-communication of the good entry was arbitrary and hence illegal, and the decisions relied upon by the Learned Counsel for the respondents are distinguishable.
Then.
Paragraph 12. Learned Counsel for the respondent submitted that under the office memorandum such and such issued by the Ministry of Personnel, only an adverse entry is to be communicated to the concerned employee. It is well settled that no rule or government.
That is not relevant, but ultimately, what did the court do? In our
The court's
opinion-
decision is, Lordship, that uncommunicated entry should be
Where is that part?
Uh, Paragraph 45, what's the page 21?
But in your case, representation is no meaning now. At best, if I am with you, then perhaps to refer it to the reporting authority to appropriately grade you. And after grading, if you get that qualifying marks, then the notional benefits, the pensionary, whatever, as per that decision that you have only relied. I think that can be done. If this court is finally convinced that yes, by not communicating, they had that itself is also.
So far communication is concerned, he came before this honorable court and your lordship has asked us to give the entry to them and we have given.
But that was
part is
done
all over.
here. That was done here, Mr. Datta. At that point of time when he missed the bus for promotion, that time this was not given to
At
him.
that time it was not.
So
given, but
I am
the-
on that.
The lacuna, if any, that has been already been rectified.
No. How? He missed his chance for promotion.
2 years, Lordship.
He missed it. How will you make that good by saying that yes, I have subsequently communicated?
No, but then
That's not
communication,
good.
non.
You see,
question on communication.
Mr. Datta, what is the purpose of communication?
That's true,
What is the purpose of communication?
but then factual.
Because
aspect will be wrong.
if we go by this decision, Devdutt, right?
Yeah.
Devdutt. What does Devdutt? What is the ratio held by the apex court in Devdutt? That
It
what
was
is
complicated.
that it is not relevant. The grading. Good, very good is not relevant.
Yes, not relevant.
What is relevant is what is the impact it will have. Ultimately, if because of that grading, he will not be eligible for his future promotion, that itself is going to adversely affect his service care prospect. That is why he is entitled for a communication. That is why he is entitled for an opportunity.
The communication was ultimately, my lord,
When-
got it. When he came.
when-
to this honorable
By
court.
then, he was already deprived of his promotion.
If your lordship's
He
order
was
is
deprived
also-
of his promotion.
Your lordship's order is also very clear. My lord, if he succeeds, if he is eligible, then review DPC will have to be constituted.
That is what I am going to do ultimately, because there is no point of sending this back by saying that now he will get a chance to represent. That is gone already. They will not get anything by sending it. It's only a delay the process. At best, the matter can be sent back to the reporting authority for grading him appropriately after whatever I find that it will be there already. In all fairly keeping in mind that he has already been assessed to have been done very good in his quality performance. There is nothing adverse reported. However, because of that 1 mark, he has lost his promotion. So keeping everything in mind, the reporting authority will appropriately grade. And if after the grading, he gets that +1, making him eligible for promotion. When was the junior officer was given promotion?
From 30th of May. 2000.
Where is that paper?
I have mentioned it in my.
Yes,
this,
just point out that. So from that, we can follow that decision thereafter. I'm only thinking. Let him finish his reply. But I think, Mr. Doctor, that is the only course which is looking like will be ultimately done. Nothing more than that.
Yes.
And of course, this is not a case which I will say that this court will not exercise its inherent extraordinary jurisdiction. It's a case where this court has to exercise it because it appears. It appears that the reporting authority has not done what he should have been done. He is clear of it. He has a responsibility. He is not some postman. He is conscious that his not giving him that 1 mark is going to cost him his promotion. He is going to be adversely affected. Not to mention, he did not even give him a communication that why he should not be given that 1 mark. It is nothing but an adverse remark ultimately. It has adversely affected him. So all that is with him, for him. Yes.
So it is in page.
See now, Mr. Dottoy, Mr. Roy, you know the court is with you. This is what you will get. So you, if you want the judgment today, then you accordingly make your submissions. I'm not stopping you, but I think you need not repeat or unnecessarily multiply authorities, because this is what I'm giving. If you want something more, you have something more to add on it, then you may say. But otherwise, I think I have reflected the mind of the court.
Yes, that's.
So,
So-
to that extent, this court is with you, because this is your reply part. You see, you've already argued your case. You're only replying, and you said you have prepared a
Summary note of
summary. So I have that. At the time of dictating, you may hear attentively. If any corrections is required, we will do it. So yes,
I will submit then, Lordship, only one judgment.
Yes.
It's a very recent judgment.
yes, give.
2025 judgment of the Honorable Himachal High Court headed by the Honorable Chief Justice regarding consequential benefit.
Yes, give me.
This judgment, Lordship, it says that
So just you said 2 judgment. One is Devdutt. Oh, 1 judgment you said, no?
no, I'm talking only for consequential benefit.
Consequential benefit.
Consequential benefit.
Okay.
Because that part, whatever Lordship has.
Yes. You give me that.
Because the Learned Senior Council was contesting the benefits of financial benefits after retirement. So this is a judgment, Lordship, where this honorable.
But even your decision, the one which you had given at serial number 6,
See,
talks
This is a
about.
very new, this is a
No,
very.
but this is your decision. You are saying that Learned Senior Council has saying, but it's not he alone.
No, I have submitted, but he's
Correct.
contesting. He's contesting.
He's not
that-
contesting, he's agreeing. He's just pointing out Avijit Ghosh Dastidar, the decision which you relied. He is only pointing out that in that case also, what was given is a retrospective promotion for the benefit of refixation of his pension and other retired benefits as per rules. Nothing wrong. I'm okay in as far as that is concerned.
No.
Anyway, what is
judgment-
this?
This judgment, Lordship, it says that if junior officers are promoted, ignoring the claim of the seniors when seniors are still in service, then his rights for promotion cannot be denied simply for the purpose of his retirement. He has to be given after due process of DPC, he has to be given all consequential benefits. If required, even a supernumerary post is also to be created. That is the judgment. This is a 25 judgment, Lordship, August 25. Original judgment was given by.
This is Himachal Pradesh.
Himachal Pradesh High Court.
The other one is Supreme Court.
That was Supreme Court.
Yes. Okay. Matok. Handwritten comments, what is this? Handwritten
Lordship,
comment?
you told that day because some of the comments in the APR were not
Oh.
legible. So I prepared that.
Okay,
comments also.
Okay. Excellent. So this summary note is only on the, it's about,
I think, Lordship, it replies to all the arguments made by the.
no,
Learned
it
Senior
is
Council.
in your facts or only on the decisions? No, facts.
That's also supported by decisions, Lordship.
Why do you have a copy?
This one,
Huh?
I have a copy.
Well, just read it. Let's read it together. It will huh?
Shall I start, Lordship? The Honorable Court by an order dated 18/3/2024, while
So
setting
this is in your earlier case. This
Earlier
is the second round.
second round. This is the second.
What is, Mr. Datta, can you ask a junior to point out the repetition number in the first round?
3362 of
WPC
3362,
3362
2012.
12. Yes. And in this, you had that I now remember. I think that time that communication was given to you,
That time coming.
isn't it? Yes, please.
The judgment was given in 2024, 2014. Judgment was pronounced on 2014.
Yes. Read.
While setting aside the review done by the Executive Director of United Bank of India, this court had instructed to redecide the representation for upgradation of APR by authority fairly, objectively, with an open mind, and pass a reasoned order. The same order also detailed the requirements of objective review to essentially contain A, clear decision, B, decision to be based on reason, C, reasons to be supported by facts and materials on records and unbiased, and D, principle of odi alteram partem to be complied. Regrettably, the impugned order dated 14/6/2024 passed by the authority and claimed to be a reasoned order is lacking on all these requirements. Now, number one, APR that I've just made it that quoted from that Devdutt judgment. In APR, it is not phraseology but effect which is important. Good is also adverse if good grading is not sufficient to give promotion. So this is the judgment. Here, even in good category, also those securing less than 60% are disqualified and those with 60% and above are qualified. Since disqualification is on the basis of minimum 60% marks, anything below 60% is adverse and needs to be justified with records and reasons. Because there is a judgment in this also by this Manudev. This judgment, in fact, they have put it in their affidavit in reply. Manudev Dahiya. It is clearly mentioned there that any adverse remarks must be justified by proper reason and facts, otherwise those will be quashed. Then, Lordship, number two, observations by the reviewing authority that reporting officer is a better judge to assess the performance is contradicting the direction of this honorable court that review should be done fairly and objectively with an open mind by an authority higher than the original accepting authority. This proves clear biasness and non-application of mind by the reviewing authority. Because, Lordship, when the judgment was passed, the court clearly said that reviews, my representation should be disposed of fairly, objectively with an open mind by a higher authority. Now, higher authority in its order is saying that the original reporting authority is the better judge. So that means he is not applying his mind. He is relying purely on whatever has been said by the reporting authority. Now, another argument has been made that the reporting officer is the best judge to assess the performance as he is presumed to be having personal knowledge regarding work ethics of the appraisee is not maintainable because the settled position of law is that subjective satisfaction of the reporting authority has to be founded by objective facts or else such remarks are to be quashed. Lordship, I have already submitted the judgment Narendra Prakash Kohli, page number. So this is a clear instruction. Then some arguments has been made. These arguments that remarks made in APR and marks assigned are not related is the main cause of arbitrariness. Very good remark against each parameter, but lower marks will make the overall assessment average. On the other hand, average remark against each parameter, but high marks may make overall assessment even outstanding.
Okay, Mr. Roy.
Yeah. Then,
All right. Heard Mr. D. Roy, give the full name, Debashish Roy, petitioner in person. Also heard Mr. S. Datta, Learned Senior Counsel, assisted by MS K. Bora, Learned Counsel, appearing for the PNB. The petitioner, a former officer of the United Bank of India, now amalgamated with Punjab National Bank, has approached this court under Article 226 of the Constitution of India, seeking a writ of certiorari for quashing the impugned order dated 14/6/2014, whereby the petitioner's representation regarding alleged arbitrary marking in the APAR for the year 2010-2011 has been rejected. The petitioner also seeks a writ of mandamus directing the respondents to treat the said APAR as non-existent and to reconsider his eligibility for promotion on the basis of the residual APRs within the zone of consideration, that is APR for the year 2011-2012, along with consequential service benefits, particularly because he has already superannuated on 31/1/2022. Correct? Stop. It is the specific grievance of the petitioner that 42 officers junior to him were included in the promotion list dated 31/5/2012 and 8/6/2012, and many of those juniors were subsequently promoted, thereby causing serious prejudice to the petitioner. The petitioner was disqualified from promotion during the year 2012 on account of alleged below benchmark APAR for the year 2010-2011. The APR in question awarded the petitioner a total of 59 marks, 1 mark short of the minimum benchmark of 60 required for consideration for promotion to the next higher post.
Next higher grade, Lordship.
Next higher grade. In the quality of performance parameter, within bracket maximum 20 marks, the reporting authority recorded that petitioner's performance was, within quotes dibba, italic dibba, very good, capable of executing discharging the job independently, does not need much supervision, but needs more penetration in tackling defaulted borrowers of all segments. Close the quotes. Yet he was awarded 13 out of 20 marks. The reviewing authority concurred and also awarded 13 out of 20. How is that quality, once again, quality of judgment and decision important? Because there you have indicated in this your handwritten note that page 49, quality of judgment and decision, that comment is satisfactory. You have anything to say there?
Those two satisfactory has been given two different marks in the same APR. In one case, it has been given 7 out of 10. In another case, it has been given 6 out of 10. And very good is also given less than.
এটা না লাগে দিয়া। দেখো। In the self-appraisal, the petitioner had acknowledged certain constraints such as the vulnerability of the area, comma, poor asset disposal scope in rural sectors, and some limited success in semi-urban pockets. Full stop. The reporting authority, while computing overall weightage, awarded 59 marks, which falls within the category of good, within bracket 55 dash D, upper symbol to D 70. The reviewing authority concurred with the overall weightage awarded by the reporting authority. It appears that because of this single mark shortfall, the petitioner was found ineligible for promotion during 2012, despite of being within the zone of consideration. At that time, your junior was promoted, no?
My juniors, 42 number of juniors are promoted.
Leading to 42 numbers of juniors, 42 numbers of officers who were junior to the petitioner being promoted to the next cadre, next grade, the next grade. Stop. The petitioner, since the marking for the year 2011 to 2010 to 2011 was not communicated to the petitioner at the relevant point of time, for which he did not get an opportunity to convince the respondent authorities as why he should not have been given one more mark so as to make him eligible for promotion during 2012. He had approached before this court by way of WPC 3362 of 2012. This court, after hearing the parties by order dated 18/3/2024,
No, Lordship, it was in 2014. The first judgment was 2014. That is in
18/3/2000,
what 18?
14, my lord, at page 30, your lordship.
18/3/2024 is which one?
This is
The
the
second-
next, second round of litigation.
There were total 3 judgments.
3, my lord.
Now, which judgment says for redeciding the representation?
Second judgment, Lordship. That
Second.
is 18/3/2000.
And before that, what happened?
Before that, communication, this order was there to communicate with the APR.
So, but by then already the promotion was done, na?
Already it was over.
Then give me the writ petition number by
3362/2012,
3,
362/2012, that is the repetition number.
wherein,
Last
this court. Wherein this court, after hearing the parties by judgment and order dated
11/8/2014.
11/8/2014, page, give me the page.
Judgment starts at page 30, 30.
लिखित होगा
3246.
पेज 30
246.
30 ना
30246.
3362 हाँ
Operative part of the judgment at page 45.
was pleased to direct that the entries in the APR for the petitioner for both the years I 2010 11 and 2011 12 be communicated to the petitioner within a period of 30 days from the date of receipt of a certified copy of this order. And liberty was given to the petitioner to make representation against such entries. And in the event such representation is being filed, the respondents were directed to consider the same fairly and objectively with an open mind. Full stop. Then the next one. Accordingly, the APR, accordingly, the APR for the years in question were communicated to the petitioner. You file a representation.
I filed a representation.
Upon perusing the APR grading given by the reporting as well as the reviewing authority for the year 2010-11 and comparing the same with 2011-12 wherein he has been given 95 marks. That falls under very good.
It is outstanding, I think.
We're falling under the grade of outstanding, comma. The petitioner submitted its representation. Yes, outstanding. Representation on
Tenth of October 2014.
10
10/10/2014.
2014. Now, after that, what happened? 11, 12, 14 order.
That, yes, 11, 12, 14 order.
After receipt of the representation dated 4/9/14 and 10/10/2014. Not, don't say 4/9, 8/10/10/14. The respondent passed the respondent disposed of the said representation by observing that after seeing his past performance and performance in the branch, though he may have done good in training college, but as branch head, his performance was not so good and marks allotted are fair and without any prejudice or bias, comma, did not interfere with the marks allotted by the reviewing authority. Stop. Aggrieved by the aforesaid speaking order, dated so and so, page 55 wala said, 11/12/2014. The petitioner approached this court by way of WPC 2102 of 2015, wherein this court, by judgment and order dated 18/3/2024, clearly held that the earlier rejection was mechanical, non-speaking, and vitiated by lack of objective consideration. Accordingly, the respondent authority was directed to reconsider the representation with an open mind, following the essential principles governing objective review. Correct?
Yes.
Relevant paragraph of the aforesaid judgment reads as under 25, 26, and 27. Despite such detailed directions issued by this court by the aforesaid judgment in order dated 18/3/2024, the impugned order dated 14/6/2024 being passed, whereby the petitioner's representation was once again rejected in a manner according to the petitioner described as an, within quote, eyewash, alleging that no objective analysis was carried out and no material reasoning was offered, explaining how, within quotes, very good performance could receive a lower marking than satisfactory. Mr. So-and-so, petitioner in person, submits that the respondent authorities have, in a most mechanical and arbitrary manner, has graded, graded the APAR of the petitioner for the year 2010 to 2011. Leading to his disqualification for promotion to the next higher grade. He further submits that despite the reporting officer having not remarked any adverse comments as such against the petitioner, against the petitioner's performance, quality of performance, and other criteria for the year in question. However, because of the marking made by the reporting authority, which was concurred mechanically without any application of mind by the reviewing authority, the petitioner, having fallen short of 1 mark of the benchmark for eligibility for promotion, to the next higher grade, the entire petition, the service prospect of the petitioner was totally jeopardized. He further submits that the apex court in the case of Manoj Kumar versus Union of India and others in civil appeal number 2679 of 2024 categorically has held that where a candidate is otherwise meeting the benchmark and no valid reason exists for below benchmark grading, the court may intervene to ensure fairness. He further submits that the APAR grading in question is totally arbitrary and inconsistent with the narrative assessment. He further submits that no reason whatsoever was given for awarding 13 marks out of 20 marks, despite, within quotes, very good assessment. He further submits that despite earlier directions of this court being passed in so and so and so and so for an objective reconsideration of the marks awarded to the petitioner in the APR in question, the same was not complied by the respondent authorities. He further submits that being short by only 1 mark should not defeat substantive justice, especially when subsequent APR shows consistent good performance. He thus seeks squashment of the impugned APR and consequential benefits. In support of his aforesaid submissions, he relies upon the following decisions. Yate sort of decision as Aru egeta 7 and 8 DD by egeta, huh? My 7 and 8 to yet mark coidis. Silum, huh? Ase, come on. No idea, sir. Per contra, Mr. Datta, Leonard Senior Counsel, submits that the writ court should not interfere in matters of assessment and grading in APAR, and that APAR evaluation is primarily an administrative function. He further submits that the petitioner though has alleged mala fide against the concerned reporting officer and also reviewing mala fide alleged against both Mr. Doctor.
Yes, you'll often find that at
Reporting as well as report
page
reviewing, however, has not made the officers concerned party respondents in the present risk proceeding. He accordingly submits that the issue of mala fide cannot be taken up in the absence of the officers concerned. I think this were majorly your submissions.
Well,
In support of his aforesaid submissions, he relies upon the following decisions. Number 1, 2, 3, 4 ke ase gutei di diba. Where is that 14,624 page?
Page 100. Lordship. Page 100.
Upon heard peruse subditia, cited case laws. Upon thorough examination of the impugned APAR for the year 2010-2011, the petitioner's representation, the earlier orders of this court, and the impugned order dated 14/6/2024, upon being Nokoba, perused with the Tapset Lekha. The observation in the impugned order dated 14/6/2024 reads as under, quote unquote, page 104. A2, A, ABC ke ase kinu moi pencil di A2 gutei to kori disu. Observation and conclusion bili kori dia. Page 109 no lekhe ase. It appears that though this court, by judgment and order dated 18/3/2024, had set aside the earlier rejection of the respondent authorities in awarding 1 mark so as to make the petitioner eligible for promotion as claimed for the year in question to the next higher grade. This court had had elaborately explained the contours of objective review and has accordingly directed a fresh reconsideration with reasons founded on materials. Where is that order? Page 100, na?
yes.
The second order? I have seen
Second order at page 58 mil,
page.
58.
No, judgment of the court. Because I've seen that Devdutt and everything has been mentioned. One,
It is 58, Lordship.
58. that's it.
5/8.
58. Yes.
relevant paragraphs of the aforesaid judgment reads as under paragraph 8 or praluba. Paragraph 8 at page 69. লিখি দিবা হা till আমি আগতে এটা প্যারাগ্রাফ দিছিলো নেকি এই জাজমেন্টৰে কিমান দিছিলো 25 পৰা দিছিলো নেকি এতিয়া তুমি হেৰিলৈকে দি দিয়া 24 লৈকে মই পিছত ঠিক কৰি দিম impugn order to quote কৰিলা নেকি 1462 1462 quote কৰিলা a perusal of the impugned order dated 14/6/2024 reveals absence of meaningful reasoning, mechanical affirmation of earlier remarks, no explanation of how very good performance translated into sub-benchmark marks. No consideration of petitioner's admitted field constraints which were acknowledged in narrative portions. Such cryptic reasoning does not satisfy the test of objectivity, fair, and reasoned review. Inconsistency between narrative assessment and numerical grading. Repeatedly, the reporting authority records very good independent working, very good within quotes, independent working within quotes, comma, minimal supervision required within quotes, yet assigns 13 out of 20 marks, which is barely above average. The reviewing authority blindly concurs. No reason is recorded explaining the rationale of such marking. Undoubtedly, the officer entrusted with the duty to write confidential reports has a public responsibility and trust to write the confidential reports objectively, fairly, and dispassionately, while giving as accurately as possible the statement of facts on an overall assessment of the performance of the subordinate officer. It should be founded upon facts or circumstances. Though sometimes it may not be part of the record, but the conduct, reputation, and character acquire public knowledge or notoriety and may be within his knowledge. Before forming an opinion to be adverse, the reporting officers writing confidentials should share the information which is not a part of the record with the officer concerned, have the information confronted by the officer and then make it part of the record. This amounts to an opportunity given to the erring corrupt officer to correct the errors of the judgment, conduct, behavior, integrity, or conduct stroke corrupt proclivity. If despite being given such an opportunity, the officer fails to perform the duty, correct his conduct, or improve himself, necessarily the same may be recorded in the confidential reports and a copy thereof supplied to the affected officer so that he will have an opportunity to know the remarks made against him. If he feels aggrieved, it would be open to him to have it corrected by appropriate representation to the higher authorities or any appropriate judicial forum for redressal. Thereby, honesty, integrity, good conduct, and efficiency get improved in the performance of public duties, and standard of excellence in services constantly rises to higher levels, and it becomes a successful tool to manage the services with officers of integrity, honesty, efficiency, and devotion. Within bracket. State of UP versus Yamuna Shankar Mishra and another, 1997, Volume 4 SSC 7. In short, when an officer makes the remark, he must echo making vague remarks causing jeopardy to the service of the subordinate officer. He must bestow careful attention to collect all correct and truthful information and give necessary particulars when he seeks to make adverse remarks against a subordinate officer whose career prospect and service were in jeopardy. In other words, due diligence has to be exercised by the reporting as well as the reviewing authority, inasmuch as any adverse remarks or marking may adversely affect the service prospects, future service prospects of the employee concerned. In the instant case, the reviewing authority, though haven't as such given any adverse remark, again, remarks against the petitioner for in the APR for the year 2010-11. However, because of his weightage awarded, the petitioner has fallen short of 1 mark of the benchmark for promotion to the next higher grade, thereby his future promotional avenues being seriously jeopardized, having been jeopardized. Thereby his future promotional avenues having been jeopardized or jeopardized, thus thereby his future being jeopardized. Huh? It appears that the role of a reviewing authority is not that of a postman so as to mechanically endorse the marking of the reporting authority. The reviewing authority has a responsibility so as to review the overall assessment and marking awarded and the marking and the weight awarded by the reporting authority, and in the case of any disagreement, after recording reasons, do so. The said power of the reviewing authority is not an empty formality. It is been provided so as to ensure a check, a review in pursuit of fairness and justice. Thus, the reviewing authority has to also exercise due diligence, care, utmost care in overall assessing the weightage awarded by the reporting authority. Since in the case in hand, the reporting authority has awarded the overall weightage of 59, which falls under the heading good, i.e. 55 to less than 70. The reviewing authority could have added 1 mark as there was nothing adverse recorded in the performance of the petitioner. On the contrary, in the quality of performance column, though he was reported by the reporting officer as very good, however, out of 20 marks, only 13 was given by the reporting authority. Similarly, for the other columns as well. The reporting officer has clearly commented satisfactory, good, and ये देखो हाँ Manoj Kumar was given by you, na?
His lordship.
Which paragraph of Manoj Kumar?
Paragraph 25, lordship.
Apt at this stage to refer to the decision of the apex court in the case of Manoj Kumar Supra. Relevant paragraphs of the aforesaid judgment reads as under. Paragraph 19.
19, 19 and 25. 25 is the final.
Paragraph
19.
18, 19, 25. Perhaps the inconsistency between narrative assessment and numerical grading as has been in the context of the present case is precisely the type of arbitrary grading the apex court considered in the aforesaid case, holding that where the grading is inconsistent with the narrative or unsupported by reasons, it invites judicial interference. Then Devdutt, na? There is no quarrel to the proposition urged by the learned senior counsel for the respondent to the effect that this court should not interfere in matters of assessment and grading of APAR. However, However, the same is subject to However, the same is not applicable if there is malafide, procedural violation or perversity. Rajendra Singh, you have given, na? Reference in this regard is made to the decision of the apex court in the case of Rajendra Singh Verma Supra. Yate pai jaba, ha, list. Relevant paragraph, quote unquote, page 147 করে para 147 দি দিবা 147 আৰু 150 দি দিবা Reading of the aforesaid judgment, it is absolutely clear that normally this court shall not interfere in cases of complaints against adverse remarks and substitute their own judgment for that of the reporting or reviewing authority. Full stop. It is because these officers alone are best suited to judge the qualities of officials working under them and about their competence in the performance of official duties entrusted to them. However, if a bona fide decision is not taken in the public interest to augment efficiency in the public service, and or the decision is not fair, this court certainly can interfere with such grading. Full stop. Okay. I'll continue at 2. এইখিনিতে তোমাৰ টাইপ হৈ নাযাব চাগে এই লাষ্টৰ এইখিনি অকমান মানে ফ্লোটো নহলে হেৰাই যাব যে এই অকল লাষ্টৰ এইখিনি মোক কৈ দিলেই হ'ব ৰাজেন্দ্ৰ হেৰিটো চেছ কৰিলো তো এইখিনি এনেকেই থৈ দিব নহ'লে দিগদাৰ হৈ যাব This court is mindful of the constitutional responsibility of a writ court under Article 226 to the effect that the same is not merely supervisory where injustice is apparent and administrative authorities have failed to correct themselves despite repeated opportunities, the court must exercise its constitutional mandate to ensure fairness, reasonableness, and non-arbitrariness under Article 14. In Dwarkanath versus Income Tax Officer, Special Circle, D. Ward, Kanpur, and others. In AIR 1966, Supreme Court 81, the Apex Court has held as under. Paragraph 4, huh? Paragraph 4 to DD. Next. Hence, the arms of the writ court are wide enough to reach injustice wherever it is found. As the Apex Court held in Manoj Kumar Supra, courts must intervene when the assessment process becomes arbitrary or inconsistent with its own narrative. In the present case, the petitioner lost promotion by a single mark, a mark unsupported by any reason or logic. Such marginal deprivation caused by arbitrary assessment offends the guarantee of equality under Article 14. The reviewing authority is not a mere countersigning authority. Its function is to apply an independent mind, semicolon, examine inconsistencies, semicolon, ensure that the numerical grade matches the narrative, semicolon, and protect against arbitrariness by the reporting authority. Reference is made to the decision of the Apex Court, to the decision of the Apex Court in Devdutt versus so-and-so in Civil Appeal number 7631 of 2002. Relevant paragraphs reads as hereunder, quote unquote, 10 and you had given 10 and Devdutt. Para 10 and only 10, na? 10. Reference is also made to the decision of the Apex Court in the case of Avijit, no, tar agote to likhi diba. Tar agote likhiba. In the aforesaid case the Apex Court held that an entry that affects promotion, even if the same is termed within quotes good, is in substance an adverse entry, comma. The same must be communicated and subjected to objective scrutiny. Likewise, in Avijit Ghosh Dastidar Supra, the Apex Court held that where reviewing authority merely echoes the reporting authority without independent evaluation, comma, the entire APAR becomes arbitrary and cannot be relied upon, and the court may grant notional promotion. Relevant paragraphs of the aforesaid judgment reads as under quote unquote paragraph 4 and 5. The present case reveals that the reviewing authority mechanically affirmed the marks without stating why a person described as very good and within quotes and independent in functioning merited only 13 out of 20 in the key category, causing him to fall short by 1 mark. Such mechanical concurrence defeats the very purpose of review and vitiates the APAR. The narrative portion praises the petitioner's performance as very good, within quotes, and that he required minimal supervision. The petitioner also faced field constraints acknowledged in the self-appraisal. Despite this, both the reporting and the reviewing authorities awarded 13 marks without explaining the downward departure from the narrative, ultimately leading to a total assessment weight of 59. Thereby falling short by only 1 mark to be eligible for promotion to the next grade. This mismatch was noted by the Apex Court in Devdutt Supra, where it held that the effect of the entry on the employee's career is determinative of its character. The petitioner's future was jeopardized solely because the authorities failed to justify the numerical grading. The court's previous judgments, as referred above, mandated a fresh objective review with an open mind. However, the impugned order dated 14/6/2024 shows no independent analysis and or fresh evaluation and or reasoning and or consideration of inconsistencies whatsoever. The respondents have demonstrated complete disregard for judicial directions passed by the Constitutional Court. A third remand in such circumstance, in the opinion of this court, would result only in further delay and perpetuate injustice. Especially after the petitioner, especially after after retirement. In both Devdutt and Avijit Ghosh Dastidar Supra Kodibaha, the apex court held that where APR entries are arbitrary or uncommunicated, semicolon, and they have the effect of depriving promotion, semicolon, the court must grant notional promotion with consequential notional benefits, but without arrears of salary. The present case is on even stronger footing because the petitioner was denied promotion by only 1 mark, the award of which is tainted by arbitrariness and non-application of mind. The petitioner has already superannuated, hence monetary arrears may not be granted, but he is entitled to notional promotion, notional pay fixation, and revised pension and retired benefits. Full stop. Correct? You've heard.
Lordship is asking me. So for that part, of course, Your Lordship.
Okay.
Without, of course, my lord.
This court is satisfied that the APAR in question for 2010 to 2011 is arbitrary, inconsistent with its narrative, unsupported by reasoning, and violative of Article 14 of the Constitution of India. It cannot form the basis of denial of promotion. The respondents, having failed to comply with judicial directions twice, a further remand would be futile. Judicial review must extend to correcting the injustice now. In view of the foregoing, I am of the unhesitant view that the impugned order dated 14/6/2024 cannot stand the scrutiny of the eye of law. Accordingly, the impugned order dated 14/6/2024 passed by so and so is hereby set aside and quashed. The APAR for the year 2010-2011 is declared arbitrary, non-speaking, and violative of Article 14. It shall be ignored for all service purposes. The petitioner shall be treated as eligible for promotion for the year 2012 on the basis of residual ARs by ignoring the APR of 2010-2011. The petitioner shall be deemed to have been notionally promoted from the date on which immediate junior was promoted in the list dated 31/5/2012, and another one was there, no? 8/6/2012. 2012. The petitioner shall be granted all notional consequential benefits, including notional pay fixation and refixation of pension, gratuity, commutation, and other retired dues, but without payment of arrears of salary, in accordance with the principles laid down in Avijit Ghosh Dastedar Supra. The entire exercise shall be completed within 3 months from the date of the receipt of this judgment. The writ petition stands allowed in the above terms and observations. No order is to cost.
Very balanced and.
Sorry.
Very balanced one.
You see, courts are the custodian of the very justice, the fairness. It has to be there. It doesn't look fair. No, 1 mark. And look at the narrative and the grading. It doesn't fit the conscience of the court.
Very correct.
Yes.
My lord, even in my mind, when I took the brief, that idea was in my mind, but as a lawyer, my
Yes,
lord, I
yes.
have to decide.
Of course, Mr. Datta.
Obliged, please.
See, that side you are only concentrating on your brief. Now,
Yes.
the moment you're this side,
Right.
the balancing.
Yes, very correct. Obliged, please.
All right, Mr. Roy. I hope you walk with a satisfaction that you have been given a patient hearing.
Yes, that's it.
All right.
Item number 1.
এখানে সবটো দিবা হা এইটোত তেওঁৰ টাইপ কৰাকে এই গ্ৰেডছ কেইটা আছিল মই যে ইটালিক্স দিছিলো ইয়াতে পাবা এইটো সেট তেওঁলোকৰ কেছ ল আৰু এইখিনি এইটো তুমি গম পাবা 1 2 3 4 6 টো যে আছে এইখিনি পিটিশনাৰ এই যে তোমাক যে মই লিষ্ট এখন বনাই দিছো না ইয়াত মই লিখি দিছো PNR ইয়াৰ পৰা চাই চাই গোটেইকেইটা কিন্তু দি দিবা দেই এইটো কি আছে না আৰু এই দ্বাৰকানাথটো বেলেগকে আছে ঠিক আছে জাষ্ট 1 সেকেন্ড লক এইটো তথ্য এইটো তথ্য আবার Yes, please.
May I please, Your Honor? So 482 application, Your Lordship, for quashing of a being in a complaint case.
Yes. Matter is ready for hearing. Ek minute. Respondent. Who is there for respondent?
The last dates, they've not appeared.
Yes. Why? It's not solved. Otherwise, I'll appoint someone.
They had appeared before, but
No, but then it's a old matter.
yes, Your Honor.
If they are not appearing, this is the consecutive non-appearance, isn't it? It's a criminal appeal. Sorry, criminal petition. So it is not fair to, if they are not appearing, we shall appoint someone. There are so many advocates in the court who are willing to assist the court, isn't it?
Complaint case.
This is a complaint case. So otherwise their names are there, isn't it? Okay. This is the third time they're not appearing. Yes, come forward. How many years of practice you have?
7 years.
7 years?
Yes.
I can appoint him. Would you like to assist the court in this matter for the informant respondent number 5?
Yes, Lordship, I will be happy.
Very well. Your name?
Prasudha Barbaro.
Heard Mr. R. Kanwar? R. Kumar, Learned Counsel appearing for the petitioner. Stop. None has entered appearance for the respondent on call. Also for the respondent stroke informant corridor. R2 na? Our respondent
Respondent number 2,
informant tar agot MP Goswami APP to dekhwai dibo. It appears that on the last 2 occasion, I-29/10/2025 and 1/11/2025 as well, there has been no appearance on behalf of the respondent, despite the names of the learned counsels appearing for the respondent number 2 stroke informant being reflected in the cause list. It appears that today as well, the names of, where is the cause list? The names of Mr. S. Das, MSK Deka, Mr. K. Malakar has been reflected as respondents for the so-and-so. However, this is the third time upon the matter being called before this court, there has been no appearance or representation whatsoever on behalf of the informant. Since the matter pertains to quashing of a complaint,
Complaint.
quashing of a criminal complaint lodged by the informant stroke respondent number 2, in the absence of the complainant, the matter is not being able to proceed further. That being so, this court requested Mr. Parshvendra Barbarua, learned counsel, who is present in the court and has consented to assist the court to represent the so-and-so in the criminal petition as amicus curiae in the present criminal petition. Let the records of the criminal petition be furnished to so-and-so by the registry, relist on, yes, by when will you be ready?
2 weeks time.
Relist the date, did you? After December, did you? Relist on such and such date. Let registry reflect the name of so-and-so in the cause list.
Deeply obliged.
Any interim order shall continue till the next date of listing.
12 December.
For hearing item number 2.
Mr. Barbaria, you indicate your telephone number also so that the registry can contact you for the papers in that slip. Your full name and DD voter. Yes.
Criminal appeal lordship. Appellant was convicted for 1 year under section 135 of Electricity Act. Altogether 6 witnesses were examined.
This is item number
2.
2. I thought someone was there a mention for item 2 in the morning?
No lordship. On
No,
the appellant side, there was no mention.
I don't know why I have a,
Oh,
yes.
I was charged under section 135 electricity.
You are alum, no?
Yes, sir. Thereafter, I was convicted for 1 year under the same section 135.
You were convicted under which section?
135 of Electricity Act
Section 135 Electricity Act.
for committing theft of electricity, unauthorizedly using electricity causing loss of
Theft.
theft of electricity, unauthorized use of electricity causing loss. of-
Anybody else appearing in this, only
No,
or
no,
PP?
This is
Yeah.
the
Huh?
state, because state has conducted the trial.
Correct, but where are they? Their names not shown. Who is appearing?
Generally, in state cases, name is not shown.
PP side is there, my lord, and for electricity board, my, there are some council, but perhaps steps facility,
No, no, no. Only
made-
steps is there because
not-
it's a
not made.
GR case
Not
and
made
trial
by-
was conducted by public prosecutor there.
No, but what about this vigilance officer ASAB? Respondent
Yeah.
number 2?
That's one number two.
I think. Service of Manoj. I'm not aware whether service was completed or not.
No, notice only I don't find has been given. First day I find heard call for TCRs, matter admitted for hearing. But he's there. You have read it, then he must be the complainant. If he is there,
But in a police case, he is not a necessary party, Lordship, otherwise.
Mr.
But we have made a party, that is
a
that's the
party.
problem, that's the problem.
you have a look.
Let me go through
You have made him a party.
Lordship, that
So
was.
Mr. Goswami, have a look while I call take up the other matter.
Standing council ACB will.
Whatever, have a look at it
Yes.
because have a look at it. 3,
Lordship, after some time.
after some time. We have it Friday, Monday.
Friday, Lordship.
Monday. Item 3. Monday corridor. Yes, next.
Item 4. She is on the way, she's on stair, my lord.
Yes.
Just 2 minutes, my lord.
You start then. Because otherwise I'll put it on Monday. If you can start, you start. What is this?
This is under PCS, my lord.
Hmm.
Judgment dated we have challenged the judgment dated 19/6/2014, passed by the special judge.
Your senior is not here. Monday. Yes, next. Next.
Item 8.
Yes, item 8. Anybody appearing? Item 8. Anyone appearing in item 8? None appears for the appellant on call. APP so and so is present. Relist on any date next week. Yes, next.
Item 10.
Item 10. Anybody appearing? Yes. Yes, what is this?
The petitioner was not convicted for 1 year for the offense committed under section 326.
Hmm?
Under for
3-2?
326, my lord.
326 ICD.
Grievous hurt.
Yes.
Grievous hurt.
1 year and 10,000 fine is awarded.
That has been, my lord, aware.
1 year and?
10,000 fine. Fine of 10,000.
Yes.
Appeal was preferred.
This is concurrent findings.
Concurrent. Now this, my lord, judgment of the appellate court has been challenged here in.
Well, Matila, he
For
was-
my lord, parting in the other condition, madam, may I refer to the affair which is at page 13, my lord.
Trial court records to Goswami Dityok. Yes. What is the main bone of contention in the criminal revision petition? What is the material irregularity committed by the appellate court?
Yes. Basically, my lord, 8 numbers of witnesses have been examined. One of the person who was stated to have been present in the place of occurrence has not been examined, number one. Number two, the materials, weapons, which was stated to have been used for commission of that offense, neither has been produced, nor has been proved that that particular weapon has been used for committing the offense. Number three, the IO who has investigated the offense, has not been examined. And so far, the allegation of 326 concern regarding fracture of the bone, that part has not been proved.
Fracture of bone.
Bone.
These are factual.
But so far, the fracture part is concerned, it cannot be stated. From the-
Medical doesn't say it's a fracture.
Medical.
Medical officer has been examined, who has examined the victim at the initial stage. Subsequently, he has been sent for some medical test, Those tests have not been
No, but in the initial test, what did the medical officer say?
Medical officers, that report.
The medical officer says that my left hand injury along with my fracture and the X-ray.
Fracture is said.
It is stated.
So far that part is concerned, fracture has been
No,
happened.
but Mr. Counsel, I hope you are aware of the limitation that you are being faced at this situation because you are not before an appellate court.
That's true,
Correct?
My lord.
You are before a revisional court.
My lord.
This is the third court. Correct?
Yes, my lord.
Both the courts have already gone and appreciated and reappreciated the evidences on record and have given a judgment against you, convicted you.
My lord.
This is concurrent finding.
My lord, so far, this matter is concerned.
Now, if you want this court to intervene, you must show this court that there is some jurisdictional error,
My
that
lord.
there has been a material irregularity or an illegality
Yes, ma'am.
committed on manifestly apparent on the record
Yes, yes. My lord, so far-
of that judgment.
my
So
lord,
this is the limited area. You have anything to show? Please go ahead.
Then, my lord, some time is needed for.
No, what sometime the matter is there for hearing.
Yes.
I'm hearing this matter. I'm sorry, no time will be given to you.
Yes, yes.
If you are
Then-
not ready to argue, we will read the judgment and we'll give the judge. We will give the judgment thereafter.
Then, my lord,
Yes.
before my lord, pointing out the irregularity, my lord, lordship has to take note of the facts behind.
Yes,
Order.
that's why now let's go to the judgment. Let us see the judgment. Let us see the judgment.
My lord.
Trial court judgment first.
Trial court judgment is as page, my lord.
Mr. Goswami, you have the evidence and the
Yes, yes,
everything
sir.
ready. If it's in vernacular,
Yes.
at an appropriate time, you might have to read it out.
Sir,
Okay? Yes.
Mail
Wait, give me the page.
17.
Page?
17.
Yes, please read.
My lord. The case at hand originated on the basis of an affair filed by Govinda Das, informing the police that the two accused, namely Girin Das and Bhupen Das, after a prior meeting of mind, wrongfully restrained the brother of the informant, used obscene-filled words, criminally intimidated the informant and his brother, and voluntarily caused grievous hurt upon the victim. On receipt of the affair, a police case being PS case number so and so was registered and is investigated. During the course of investigation, the accused was arrested and released on bail. Statement of material witnesses were recorded, and after the usual formalities, search sheet was laid by CS number so and so. On receipt of the search sheet, cognizance of offense was taken. Processes were issued, and attendance of two accused was secured. After hearing the parties and considering the materials on record, charged under section 341, 326, 294, and 506 of IPC, read with section 34 of IPC was framed. The accused had pleaded not guilty to the charges. Points for determination. A. Whether the accused Girin Das and Bhupen Das on 15/2/2009 at February after a prior meeting of mind and in furtherance of common intention use obscene-filled words against the informant and his brother. Whether, number B, whether the two accused in furtherance of common intention thereafter wrongfully restrained the brother of the informant. C, whether the two accused in furtherance of common intention thereafter voluntarily caused grievous hurt on the victim by means of dangerous weapon. D. Whether the two accused also criminally intimidated the victim before leaving the place of occurrence. Discussion, decision, and reason thereof. I have perused the report and heard the parties. I would like to begin by reading the deposition of the medical officer examined as PW7, Dr. N. Sharma, has deposed that on 16/2/2009,
Total PWs are 3,
8 matters.
8.
8.
Okay.
PW7 Dr. N. Sharma has deposed that on 16/2/2009, on police requisition, he had examined Madan Das, a male person of about 45 years, and found fracture of the forearm, accompanied by incised wound. PW7 opined on oath that the injury was grievous and caused by sharp cutting weapon. In cross-examination, nothing material could be elicited. The identity of victim also could not be put in doubt because examination was conducted on police requisition and the inquiry report was collected by the investigating officer during the course of investigation. What thus follows is that on the date of the incident, Madan Das received grievous hurt caused by a sharp cutting dangerous weapon. The limited question that now needs to be answered.
Kuthar is seized.
My lord?
Kuthar was seized.
Yes, sir. Kuthar was seized.
Yes.
The limited question that now needs to be answered is as to who is the author of the injury so caused. The best witnesses on this point would be Madan Das, examined as PW1. He has testified that on the date of incident, when he was trying to clean the blockade to the drain, accused Girin Das came and attacked him with a kuthar. It is further testified by PW1 that as a result of the attack, he suffered cut injury on his hand and had to be treated at Rongya and then at Guwahati. Now let me read the evidence of the informant Govinda Das, examined as PW2. He testified that a verbal altercation took place between the two accused and Madan Das relating to the cleaning of the drain, and then suddenly accused Girin Das attacked and assaulted the victim. In cross-examination, the defense has merely put some suggestions to these two vital witnesses and done little else. PW1 and 2 have thus remained unchecked during cross-examination. PW2 supports and corroborated PW1 on material point and thus fortifies the prosecution version. Now let me read the deposition of the other three ocular evidence: PW3 Bhagya Das, PW4 Ganesh Das, and PW5 Apati Das have averred that they saw accused Girin Das attacking and assaulting Madan Das with a kuthar. These three witnesses further testified that kuthar fell on the left hand of the victim PW1, and as a result, the victim sustained severe injuries. What needs to be also noted is that these three independent witnesses, PW1 and PW2, have nowhere stated anything against co-accused Bhupen Das. I have read and reread the evidence on record. I find that the version of PW1 is corroborated by other prosecution witnesses. The doctor examined as PW7 give added strength to the prosecution versions. None of the eyewitnesses was found to be inconsistent to his previous version, and they could not be second during cross-examination. Does it stands proved that on the date of the incident, accused Girin Das voluntarily caused grievous hurt to PW1 by means of a dangerous weapon, but there is no material to lead to an inference that co-accused Bhupen Das shared the common intent to cause such hurt to the victim. Prosecution has not laid evidence to show any prior meeting mind and or acting together in furtherance of common intention. I would also like to point out there is no evidence at all of criminal intimidation and wrongful restraint. In the absence of the exact words being spoken by the accused, the charge under section 294 IPC also fails. In the result, I hold that accused Girin Das is guilty of offense punishable under section 226 IPC, and he is accordingly convicted.
Okay. Just if you permit me, I want the PP to read out PW1 and 2 from the records. Huh?
Sure.
Go ahead.
PW1 is the victim, my lord. মই চিনি পক্ষক চিনি গ্ৰীণ দাস মোৰ কুঠাৰে হাতত ঘপিয়াইছিল।
মোৰ
হাতত ঘপিয়াইছিল।
Yes, yes,
অনুমান
understood.
1 বছৰ আগত মই মোৰ ডাঙৰ ভাই অমৃত দাসৰ লগত নলা এটা পাতি থাকো তেতিয়া গিৰিনে পিছফালৰ পৰা আহি মোক ঘাপ মাৰি দিয়ে। গিৰিনহঁতে নলাটো বন্ধ কৰি থৈছিল আৰু মই নলাটো খুলিছিলোঁ। সেইকাৰণে তেওঁ মোক মাৰে। মোৰ বাওঁ হাতত ঘাপ মাৰে। মোক ৰঙিয়া হস্পিটাললৈ নিয়ে। ৰঙিয়াৰ পৰা মোক গুৱাহাটী GMC নিয়া হয়। তাত মই চিকিৎসাধীন আছিলোঁ। একমাহ চিকিৎসাধীন আছিলোঁ। মোৰ ককাই গোবিন্দ দাক ওচৰ দিয়ে। This is the chief, man. Now in cross, আমাৰ ঘৰ লগালগি। সত্য নহয় যে মই আগৰ পৰা আমাৰ কাজিয়া আছিল। সত্য নহয় যে সাক্ষী মিছা কৈছে মই থাকোঁতে। সত্য নহয়
মই কোৱা মতে কোনো ঘটনা
মই কোৱা মতে হুকুম হোৱা নাই।
মই কোৱা মতে
মই
হোৱা নাই।
সত্য নহয় যে মই কোৱা মতে
that suggestion he denied.
He denied. That is PW
One.
1, my lord. Yes.
Then
specific.
2,
Then 2, my lord. 2.
because I think the main witness is 1 and 2.
1 and 2 and 1 and 2 is supported by both 3 and 4. Those are independent witnesses.
So 2, read 2.
2. মই গুচৰীয়া ইনফৰ্মেণ্ট গুচৰীয়াজনক মই চিনি পাওঁ। ইমান তাৰিখে পুৱা 6টামান বজাত ঘটনা হয়।
Who is PW2?
Who is the my lord? He is the informant.
How is he related?
He is
Brother of the victim.
victim, my lord.
Yes, please.
ঘপি আহিছিল বাওঁ হাতত। গিৰিনে
Huh?
গিৰিনে
No, no, he saw.
yes, he has narrated the incident, not said he saw. ঘটনাটো হয় গিৰিনে মদনক কুঠাৰেদি ঘপি আহিছিল বাওঁ হাতত। মই সেই সময়ত মোৰ চোতালত আছিলোঁ। ঘটনাটো মদনৰ চোতালৰ কাষত থকা কাষত হয়। তেতিয়া গিৰিনে ভূপেন আৰু মদনৰ মাজত তৰ্কাতৰ্কি। মই আগবাঢ়ি যাওঁ। মই ঘটনাস্থলী নাপাওঁতেই গিৰিনে মদনক কুঠাৰেদি বাওঁ হাতত ঘপিয়াই পলাই যায়। তেতিয়া মই 108 মাতো ৰঙিয়া হস্পিটাললৈ লৈ যাওঁ। This is what he said in chief, my lord. And in cross, my lord, he has denied সত্য নহয় যে দেখা
So not shaken.
not second. This is all the suggestion he has denied. Now PW3 is the important matter. He is an independent witness.
Yes.
মই উভয় পক্ষকে চিনি পাওঁ। অনুমান 2 বছৰ আগত ৰাতিপুৱা ঘটনা হয়। গিৰিনে আৰু মদনৰ সীমাক নলা লৈ ঘটনা হয়। মই সেই সময়ত মোৰ শুই আছিলোঁ। মই হাহাকাৰ শুনি আগবাঢ়ি আহোঁ আৰু দেখোঁ যে গিৰিনে মদকক কুঠাৰেদি বাওঁ হাতত হাত মাৰি দিয়ে। মই দেখোঁ যে
So 3 is also eyewitness.
3 is the eyewitness. 3 and 4 also is the eyewitness. আমি তেতিয়া মদনক লৈ আহোঁ আৰু
So
108
3 কৈছে 3 আৰু 4 না?
3
He used another name. So that is 4.
no, but he is 3.
No, 3 said along with him someone.
No, he said he has not said anybody's name.
Ami, he said.
Yes, my lord. মই he said মই হাহাকাৰ শুনি আগবাঢ়ি আহোঁ আৰু দেখোঁ যে গিৰিনে মদনক কুঠাৰেদি বাওঁ হাতত ঘাপ মাৰিছিল। Then he said that আমি তেতিয়া, that is perhaps regarding the presence of 4, my lord. আমি তেতিয়া 108 মাতি হস্পিটাললৈ লৈ যাওঁ।
Okay.
And
Then
my lord,
Cross.
cross part গাঁৱৰ নামঘৰৰ কাজিয়া হৈ 2 ফৈদ হৈছিল আৰু এটা ফৈদ গুচৰীয়া আৰু আন এটা ফৈদ পদকীয়া আছিল। আগৰ পৰা নলালৈ মনোমালিন্য আছিল।
আগৰ পৰা নলালৈ?
নলালৈ
Huh.
because of that drain there is নলালৈ মনোমালিন্য আছিল। সত্য নহয় যে মই ঘটনাটো দেখা নাই। ঘটনা হোৱা নাই। কোনো ঘটনা হোৱা নাই। সত্য নহয় যে মন্দিৰত মই মিছা গোচৰ দিছোঁ। This is 3. Now 4, my lord. মই উভয় পক্ষক চিনি পাওঁ। অনুমান 1 বছৰ আগত ঘটনা হৈছিল। আমাৰ চোতালৰ কাষত থকা নলাৰ ঘটনা হয়। মই সেই সময়ত ঘৰত আছিলোঁ। সেই সময়ত ভূপেন আৰু মদনৰ মাজত তৰ্কাতৰ্কি লাগি আছিল। নলাটোক লৈ কাজিয়া লাগিছিল। মই দেখোঁ যে গিৰিনে মদনক বাওঁ হাতত কুঠাৰেদি ঘাপ মাৰি দিয়ে আৰু পলাই যায়। আমি মদনক হাস্পতাল নিয়াটো হয়। মোক সোধপোছ কৰা নাই পুলিচে মোক সোধপোছ কৰা নাই সত্য নহয় যে মই কোনো ঘটনা হোৱা নাই বুলি কৈছো so 3 and 4 my unequivocally my supported the version of 1 and 2 exactly similarly what they posted. May I go to the medical part? Medical is my PW7 man.
Because this part is not, I didn't find 3, 4 in the trial court judgment. It was not.
No, I am going to that one.
Uh-huh.
Let him complete my lord.
Now my lord.
Anyway, this, since he's read, you need not read them, but if you want to point out something, you may point out, huh?
And in 5 also my lord, he is also acted. He also,
5 also I have witness.
yes my.
What does 5 say?
মই দেখো যে মদন দাস আৰু পদকীয়াৰ মাজত তৰ্কাতৰ্কি আছিল তেতিয়া গিৰিজে মদকক কুঠাৰেদি বাওঁ হাতত ঘাপ মাৰে
So this
But-
part has, everybody have said it in one voice.
one voice
That the accused has had struck the victim with a
X
X on his hand,
and hand man in the left
and
hand.
the doctor says that is fracture.
That is fracture. Doctor says my lord on duty requisition I had examined
And
Madan
in
Das
his opinion, the heart is grievous.
previous with sharp weapon.
So that is also corroborating.
Also my left
Okay,
arm.
now appellate court
Yes.
judgment.
Just affirm my lord.
Let's see, have they analyzed? What is the analyzing of the
Fine.
appellate court?
I am reading it then.
I think appellate court has taken note of 4, 3, 4, everyone.
Page 20.
4 is, yes, I've seen.
3, 4.
4 is also been taken. Yes, then what is there?
Yes, I am
Yes,
submitting.
your arguments. You can sum it.
I can sum it up. My lord, so far the criminal liability is concerned, my lord. My lord,
IPC.
while my lord, conviction has been my lord imposed, my lord.
Huh?
While the conviction has been imposed, my sentence is imposed,
Yes.
then my lord, the conclusive proof, the principle of proving the fact conclusively has to be followed by.
Yes.
That's,
That has been
Yeah.
proved.
no, my lord, I am submitting that. my lord.
You see, you may submit,
But-
but you, as I have said, it
I am
appears,
submitting
you
that
see.
all the witnesses are my lord, family members.
You see, Mr. Counsel, I'm again repeating myself. You are before a revisional jurisdiction. Both courts have gone through the evidence of the victim as well as the eyewitness, one or two independent. They have taken a view.
No, indeed.
Now, if they have taken a perspection merely because they are not eyewitnesses, they are related witnesses, revisional court is not going to interfere with that.
They are not,
Hmm.
independent witnesses are not examined. My lord, one independent witness is there. He stated, he is the
All right,
hearsay.
I have taken note of your argument.
Number 2, my lord, by which weapon,
By which?
weapon, that is the offense was committed. That is a very vital aspect, my lord. The weapon which has been stated to have been used, whether that part is proved.
Okay, noted. And
Because my lord, seizure list has been made.
Hmm.
The
Yes.
X was seized, my lord. But whether that X and that seizure list was proved.
Okay, noted.
Because
And
my lord, when the material, my lord, weapon has not been produced and my lord proved, the offense,
understood.
for
You
committing
you mean to
like
say non-production of the X in the trial has amounted the prosecution has made the prosecution case fatal.
my lord,
I've understood. I've noted. Now it is for the court to deal with that argument.
my lord. Yes, my lord.
Yes.
I am submitting in regards to
I
the
have
judgment also.
non-X. Okay.
my lord. Now, my lord, the witnesses who has deposed against the, my lord, present petitioner. The Madan Das, that is the victim. PW 1, 2 are brothers, 3 is the sister.
I've noted related witness,
Family member.
family member. Noted.
Now, my lord, Rossi may take again the
Family members are PW 1,
2,
2,
3,
3,
4.
4 is family member.
Yes, my lord.
Psylocke,
Date of birth.
you said independent.
Yes, sir.
Date. father's
My,
name.
my father's name is
Gorgoram Das.
Ganesh. Oh, yes, sir. Gorgoram.
Brothers, no, all are brothers.
Wait, let him verify
Yes,
because
yes, my lord.
family members.
Yes. father's name is same.
4 and then
Because-
5.
Yes, because they
Five
are
is the
starting
sister.
with that.
5 and 6.
I know both
Five
the
is
parties.
sister, my lord.
So family members.
My lord. Six is my lord independent, my lord.
6 is the only independent.
My lord.
Can you read 6 once again,
Lordship.
Mr. Goswami?
Lordship.
Matok.
এক বছৰ আগতে 5টামান বজাত হয় মই তেতিয়া শুই আছিলো কাজিয়া কথা শুনা পাই মই আহো আৰু মদন দাসৰ ঘৰত যাওঁ মদনৰ গাৰ বাওঁ হাতত জখম দেখো পিছত 108 মাতি অনা হয় শুনা পাওঁ যে গেইনে তেওঁক হপিয়ালে
Okay. So he came later.
He came later, man.
Yes, sir. Now, my lord, medical report.
Who sees the weapon?
আয়ো man.
Where is the IO?
I will not examine.
I was not exam-
Not examined?
not exam.
Okay. Very well. Anything else?
Now, my lord, so far the medical, my lord, officers, my lord, statement is concerned, my lord.
Give me the decision. You said non-examining the
My-
X.
Believing it to be my lord the interested witness, it is not fatal to the.
That is okay.
My lord, so far the
You
relation.
see, that I am not taking because one witness, even if one eyewitness also, if it's
Such-
credible and reliable, this court will take it.
Yes, yes. my lord.
So that is well settled law.
Well settled.
He's argued, but
I'm not denying-
non-examining the IO and that X, show me what decision you have.
My lord, if you lordship permits, my lord, because my lord, all the neighbors, my lord, and adjacent, my lord, the house is the informant and the present petitioner is the same locality neighbor, my lord. My lord, what happened, my lord? And the incident was not.
I cannot go into all that aspect.
However,
Mr.
my lord, so
Counsel.
for conviction of that particular person, who has my lord two minor sons, my lord, he
Where?
daily with honor, my lord. Now, while my lord, seizing the my lord weapon, that my lord seizure list as well as the seizure witness as well as the IO ought to have been examined by the my lord learned trial court below. That was not done. So my lord, so far the use of weapon has not been, although stated, my lord, not been proved. Now, my
Okay.
lord, so far treatment part is concerned, my lord. My lord, so far grievous heart is concerned, my lord. The so far incise own and the subsequently, my lord, statement as regards to fracture had taken place on bone, my lord. That has been, my lord, substantiated and derived from a report which has been committed under examination. That
Mr.
is the
Goswami,
X-ray, my lord.
That 3, 4, 5, 6, you might have to help in dictating that evidence part because it's not reflected in the trial court. So please, I'll need it now.
And so-
There is some app nowadays. If you
Yes.
just
Please.
place it, the entire English version will come. I think Mr. Smith knows. He's smiling.
Provided, my lord,
Mr. Nath also knows, I think.
What
Yeah,
the
you know,
blessing?
Mr. Smith. The correction part, Mr. Goswami will sit with him, sit with him. Come. Give him that. Yes.
and so far the medical officer statement is concerned as regards to my lord, grievous heart is concerned. He has my lord, derived the information from my lord, exam test report, my lord. That is the X-ray. The X-ray is the my lord, the source from which the medical officer has stated the fracture was taken place. But that
Sorry, I'm sorry, I didn't get you this part of your argument.
Yes.
What are you trying to say?
I'm trying to say, my lord, the medical official who has stated that grievous heart was taken place. So, my lord, grievous heart, this word has been derived from a report, medical examination report, my lord. That medical examination report accompanied by the X-ray, my lord, which is vital document to be produced.
But
and
he's an
submitted-
expert,
My
Mr.
lord, so far
Counsel.
that expert is, but he has not.
He's
gone
an
to it.
expert. You see, he is an expert. Both the courts have given that
Second part, man, I'm going to each and every point. So far, the examination of the man accused is concerned.
Hmm.
On the day of occurrence.
Now,
I
Mr. Counsel, in 313, what did you do?
Denied them. my lord.
Simple.
You have not given any explanation.
Honest-
During cross-examination, you did not took any plea to,
May I submit, madam?
you have
Due
not
to the-
taken
Due
the,
to the fault of any matter engaged person.
not that, you should have given evidence. You have not given any
Even-
evidence.
Madam,
Sorry,
One,
this is a revisional court, Mr. Counsel.
yes, may I submit one thing, my lord?
I don't see any illegality committed by the appellate court or the trial
Yes.
court.
Then my
Yes.
lordship may take note of the judgment of the.
Yes, give me the judgment. I've been asking for the
Yes,
judgment.
yes.
Give.
Lordship may pardon me because I am not writing all this, my lord, in list, my lord.
No, then that's all right. You just give whatever you have. Your name?
MP Sharma. May I give all the judgments, my lord, if you lordship permit?
You don't need so many judgments, but
No, no.
one or two, whatever. Yes,
No,
in,
no.
the first judgment, Kipa Siro. This
Right.
is for what?
My lord, non-production of my lord material object by which the offense was committed is fatal. To
Which
prove-
paragraph?
On paragraph, starts from paragraph 32, my lord. Relevant part is at page 38, my lord.
Page or para?
38, paragraph number 38 and 39. 36 from, lordship may, if you lordship, please to 36 from 36, my lord. It will be.
All right, noted. Next.
My lord.
Ani dia Kamal, aru decision diba? Rupak, তেওঁলোকক কি help লাগে দি দিবা, print লাগে যে translations. Mr. Goswami, you would sit down. Why sit and do it properly? Till then, I will look into the case laws. You sit and do. Yes. Which one? Sadhan Chaudhary?
Sadhan Chaudhary.
Yes. Paragraph?
Paragraph, a long paragraph, my lord. Paragraph 17, my lord.
On what point?
My lord, material witness, non-examination material witness.
Material?
Witness, my lord.
Witness.
My lord. Here, my lord, if your lordship take note of the PW1 statement, my lord, the victim statement. He mentioned one person's name who was present at the
Okay.
time of place of.
Noted.
Amrit Das, my lord.
Next. Next.
Next, my lord, Swal Das has been, my lord, as regards to my lord, failure to proceed with the material witness, presumption under investigation.
Yes, I've understood. Next point.
These are the vital points. my
No,
lord.
no. This decision. What are all these decisions?
Swal Das, my lord.
No, Habib Muhammad.
Habib Muhammad has been.
Sadhan Chaudhary is gone. Witness. That is
But-
on witness. Now, what
Habib-
about Habib Muhammad?
So for Habib Muhammad is. concerned,
Paragraph?
Last portion of the paragraph 10, my lord.
Point.
Non-production of weapon as well as the material witness.
So both.
Both, my lord.
Okay. Next.
Others are similar, my lord.
But just indicate the paragraph because I'll have to take
My lord,
down
my
in
lord,
the
yes,
judgment.
yes. Paragraph 13 in Swal Das, my lord.
Sawaldas is paragraph
13, my lord.
1-3.
Yes, my lord.
And this is witness or weapon?
Witness, my lord.
Witness.
Paragraph
Okay. Then
8 and 12.
which one? Thulia.
Thulia, my lord.
Paragraph
8 and 12.
8 and 12. Witness?
Witness,
Only witness?
witness and my lord. Witness. witness.
Only witness.
Witness. Here, my lord, to sum up my submission before lordship. Basically, my lord, while my lord convicting the my lord petitioner for commission of the offense, which has been alleged to have been committed through an weapon, has not been proved, and so far the seizure list is concerned, that was also not my lord produced, proved, and submitted by the authority, my lord. And so for the examination of the victim, that is very much important because of the fact that at the time morning around
Examination of the victim means?
victim, my lord, victim was my lord suffered on 15th of the particular month, 15 to 2009, at around 6 a.m. He was examined on the next day. And he stated he was first taken to Rongia Hospital, thereafter to GNCH. and no medical documents as regards to making a treatment or undergoing a treatment has been produced and proved. That ought to have been, my lord, placed by the
Okay.
investigating authority. Nothing has been proved except the medical report submitted by the medical officer. My lord. And so far,
Okay.
undergoing treatment is concerned, as regards to his own, that is not proved, my lord. And so far, enmity is part is concerned, PW4 stated, PWC stated that there is an enmity as regards to the boundary.
Nala.
Yes, my lord.
Anything more? You are repeating. Anything more?
No, so far that part is not, so since there is an enmity, my lord, there's a possibility of, my lord, taking such, my lord, adverse step as against the, my lord, petitioner, my lord. My humble submission before lordship is such that unless and until the offense is proved beyond, my lord, beyond, my lord, conclusively proved, he cannot be punished, my lord. That is my humble submission, my lord.
We tried to translate, but it's not correct what has come out, my lord, because
It's all right.
It's-
They are very
yes,
short,
and
so you
can-
can just help me only on that.
I will read
See
exactly,
how it comes.
read exactly what is there.
All right.
My
Take down. Anything you want to add, Mr. Goswami?
Regarding all this, that these are not fatal, my lord, when the ocular evidence is very much trustworthy, my lord. And there are.
No, he has one, he's just highlighted one point, which I'm thinking. You see, it has come from the prosecution witness that there has been some dispute regarding some Nala. Right. And now all these witnesses are all related witnesses. The only independent witness is PW6, but he came subsequently and he heard that accused. That's hearsay. What do you have to say to that?
That is what I'm saying, sir. Since believing it's my lord, they are related, my lord, but it cannot be disregarded because of their relation, my lord. That is a settled position of law, man. Because there are three witnesses, they are saying the same, exactly the same.
What about their 161?
161, just I am checking it out.
Check, because there is no cross-examination that they have improvised.
Yes. my lord.
So
There is
if
no-
they have been consistent with their stand, perhaps they can be trustworthy.
Yes, yeah, lord. And in the left hand from the back, that is everything is.
Like
similar.
a graphical elaboration of the
Yes,
incident.
yes.
Anything more? No, just check that 161. Have a look at it. Yes, Mr. Sharma, you take a seat.
Well, CD part is not here.
Okay. But there was nothing mentioned in the cross
No.
about
No,
police
just because-
statements.
In the last, my lord, regarding.
But why was the IO not examined?
Yes, my lord, IO is not.
What happens if IO not examined?
That is also, my lord, since if the, my lord, IO is for the corroboration and if there is any contradiction that has occurred during the cross examination, that whether it has been said or not. Because PW 2, 3, my lord, when in cross, my lord, nothing, my lord. PW 4, my lord, only stated that, my lord, সত্য নহয় যে মই কোনো ঘটনা হোৱা নাই. Nothing, only one line cross, my lord. And they are also not disputed the medical report, my lord.
Hmm?
Medical report, my lord. Medical officers.
Injury sustained by the victim can primarily sustained by falling on.
Cross is there, my lord, stated that,
falling support.
except it is not available. It is not a fact that I have submitted the report without going through the X-ray.
Just read the medical evidence once again.
In 16 to 0.
And where has these things happened?
In their vicinity, my lord, because of a, my lord, blocked drain, my lord.
Yes, read it again, please.
I am going to the, my lord, medical, my lord.
Yes, please.
In 16 to 09 on, I was posted at Rongya CAC. That day I was on duty. On police requisition, I had examined one Madan Das, 45 years, and found following injuries. incise looking wound, 7 centimeter into 2 centimeter in left forearm. X-ray shows fracture of left radius. Nature of injury is grievous. Weapon is used is sharp cutting weapon. That is.
Process important, man.
Okay, yes, write down. Heard Mr.
MK Shum.
MP.
MK.
M.K. Sharma, na? Learned counsel appearing for the petitioner also, sorry, on petition. Also heard Mr. M.P. Goswami, learned APP for the state respondent. By way of this application under section 397 of CRPC 1973, read with section 401 of the said code, the petitioner is assailing the impugned judgment and order dated 27/10/2014, passed by the learned session judge Kamrup Amingao in criminal appeal number 29 of 14, arising out of judgment and order dated 26/6/14, passed by the learned SDJM Rangia in GR case number 138/2009, whereby the sentence passed by the learned SDJM Rangia whereby sentenced to undergo 1 year simple imprisonment and fine of rupees 10,000 passed by the so and so has been upheld. The prosecution case in brief is that on 15/2/2009, one Shri Madan Das had lodged an FIR before the officer in charge of Rangia police station alleging inter alia that the accused petitioner and his brother wrongfully restrained the informant's brother PW2. Victim is 1.
Victim is one man.
PW1 and caused grievous hurt upon him, and to that effect, the police had been requested to take action against them. Accordingly, a case was registered. Thereafter, upon completion of charge sheet investigation, the police submitted charge sheet against the accused petitioner and co-accused under section 341, 326, 394, 34 IPC. Upon trial being commenced, as many as 8 witnesses have been examined by the prosecution side, and they have also been cross-examined by the defense. However, the accused petitioner have examined none. Thereafter, the learned SDJM Rangia, upon perusing the materials on record, delivered the impugned judgment and order dated 26/6/2014, whereby, though the co-accused had been acquitted, however, the accused petitioner has been found guilty under section 341/249 IPC. Accused petitioner has been found guilty under section 326 IPC and accordingly convicted and sentenced to undergo 1 year simple imprisonment and also fine of rupees 10,000. Aggrieved by the aforesaid conviction and sentence, an appeal has been preferred, which the appellate court, after analyzing the evidence on record by judgment and order dated 26/6/14, was pleased to dismiss the same. Situated thus the present appeal. Present revision petition, sorry. Mr. So-and-so submits that both the courts have failed to appreciate the evidence on record in true perspective. Stop. He further submits that despite one material witness, Amrit Das, being present at the time of incident at the place of occurrence, with whom the victim was talking about the drain, the prosecution having not examined him, the impugned conviction stands vitiated. He further submits that both the courts ought to have considered the factum of injury in relation to the facts and circumstances assailed by the prosecution, including medical treatment, period of treatment, date of treatment, and the statement of the medical officer. But having not considered the same, the impugned judgments and the impugned conviction and sentence is liable to be interfered with. Stop. He further submits that there is lack of confidence of all the witnesses as to injury and treatment of the victim. He further submits that all the alleged eyewitnesses being family members, considering that there has been enmity between there is a dispute as regards a drain between the parties, the same are not trustworthy, and hence the judgment of the trial court as well as the appellate court in convicting the accused petitioner by relying the said related eyewitnesses is totally erroneous and perverse. He further submits that there was no evidence as to the use of such particular weapon or any expert's opinion which conclusively proves that only the petitioner accused has inflicted injury, and that too only by the said weapon. As such, in absence of such material evidence, both the courts ought not to have sentenced the accused petitioner. Stop. He further submits that the impugned judgment and order accordingly suffers illegality. Stop. He further submits that the courts, while passing the judgment and order, have denied the benefit under the relevant provisions of the Probation of Offenders Act 1958. In considering the fact that both the informant and the petitioner accused are neighbors to each other, and in relation to the legislative intent, as well as other law and equity, full stop. He further submits that what were you saying, some daily wage earner or something?
Daily wage earner.
He further submits that the accused petitioner is a daily wage earner and is residing in the aforesaid locality along with his wife and two sons, aged about 6 and 11 years old, and is the only bread earner of his family. Hence, the benefit under the relevant provisions of the Probation of Offenders Act 1958 ought to have been given to him Full stop. For contra, Mr. No, sorry, I got eight along. In support of the aforesaid submissions, he relies upon the following decisions. 1, 2, 3, 4, 5. Vipento dilu নহয়? তাত কৈছো নহয় উইপেনৰ কথা যে উইপেনটো চিজ কৰা আহি গৈছে না গোটেইকেইটা দি দিব লিষ্ট এখন বনাই সুপ্ৰিম কোৰ্ট গীতা আগতে দিব তাৰপিছত হাইকোৰ্ট For contra, Mr. MP Goswami, learned EPP for the state respondent submits that merely because the eyewitnesses are family members of the victim, there is no hard and fast rule for relying on such testimonies for convicting the accused under section 326 IPC. He further submits that, however, before convicting, the court shall examine as whether such related eyewitness stands the test of starling witness. Stop. He further submits that in the present case, the testimony of the eyewitness being fully corroborated by the medical experts' evidence, the testimony of the eyewitnesses are wholly reliable and credible, and hence the impugned judgments and conviction being based on evidence ought not to be interfered by the by this revisional court. He further submits that non-examination of one person as claimed by the accused petitioner is of no consequence inasmuch as the other witnesses who has witnessed the assault has been examined and has remained fully consistent right from the initial stage. He further submits that the defense has not shaken their testimony whatsoever during it has not shaken their testimony during cross-examination. He further submits that the defense has also not given any explanation and or adduced any evidence in support of the defense. I have given my prudent consideration to the arguments advanced by the learned counsels appearing for the parties and have perused the material available on record. I have duly considered the case law cited at the bar. It appears that on the basis of an FIR being lodged by PW2, the investigation commenced, leading to submission of charge sheet and trial. It appears that PW1, who is the victim himself has deposed that the incident and has deposed that the accused petitioner gave blows on his left hand on the date of incident when he tried to clear the drain by removing the blockade. He further deposed that the accused petitioner came and slashed him from behind on his left hand, and at that time his brother Amrit Das was also present. He further deposed that on being slashed, he fell down and then he was taken to Rangia Hospital, and thereafter he was shifted to Guwahati Medical College. During cross-examination, he stated that the house of the accused is contiguous to their house, though a suggestion has been made that there is enmity between them. However, he denied the same. PW2, the informant, deposed that on the date of incident around 6 am, his brother PW1 was slashed by accused with an X on the left hand, and at that time he was present at the courtyard of their house from where he witnessed the incident. He further deposed that on the date of incident, there was an altercation in which the accused petitioner and Bhupen were in one side and PW1 on the other side. And hearing the altercation, he proceeded to the place, and before reaching the place, the accused petitioner gave blow on the left hand of Madan by an axe. He further deposed that thereafter he took the victim PW1 to Rangia Hospital by 108 ambulance. And later on, he was taken to GMCH. He further deposed that the altercation took place over the blockade of a drain. During cross-examination, he denied the suggestion that there was dispute from earlier over the drain. PW3. Who is PW3?
PW3 is my lord, Bhagya Devi, the sister-in-law
Who is the sister-in-law
of the victim. My
of the victim? Deposed that on the date of incident, when she was cleaning utensils near her tube well, she heard a hue and cry and proceeded to the place and saw the accused petitioner giving blow on the left hand of the victim PW1 by an X. She further deposed that the victim PW1 was sent to hospital by 108 ambulance thereafter. She further deposed that the incident occurred due to blockade of the drain. During cross-examination, she deposed that there was a dispute from earlier between the parties over the drain, and there were two groups in the village, and both the accused and the injured were members of the two different groups. PW4, who is also an eyewitness. And who is 4?
Who is the brother of the victim as well as the husband of the PW3, my lord.
PW4, who is another brother of the victim, deposed that he saw the accused petitioner slashing PW1 victim by means of an axe. He further deposed that there was a quarrel between them over a blockade of a drain. Who is 5?
5 is sister of the victim.
PW5, who is another sister of the victim, also supported the testimonies of PW1, 2, 3, 4. PW6, who is an independent witness, arrived, deposed that he arrived at the house of PW1 after hearing about the incident, and on reaching his house, he noticed injury on the left hand of the victim. During cross-examination, he deposed that he does not know anything about any standing dispute between them. PW7, who is the medical officer who examined the victim PW1, on the date of occurrence, no?
No, subsequent day.
on,
Next day, my lord.
on the next day after the occurrence, deposed that on 16/2/2009, on police requisition, he had examined the victim, PW1, and found fracture of the forearm accompanied by incised wound. Huh?
Incised looking wound,
Incised looking
one
wound
7 centimeter into 2 centimeter in left forearm.
Paile? Yes. He further opined that the injury was grievous and caused by sharp cutting weapon. During cross-examination, nothing material could be elicited.
Cross part may be, madam, noted, madam. On PW7's cross part may be.
Yes, what is there?
May I read it also? That's findings.
What is there, Mr. Goswami?
Yes. It is not a fact that I had not examined properly. The injury sustained by the victim can only be sustained by falling on sharp object. X-ray plate is not available in the record today. It is not a fact that I had submitted a report without giving through X-ray. I had not mentioned the name of police.
During cross-examination, he clarified that the X-ray kotha ki koise, that the X-ray plate is
Not available in the record
not available on the record
today.
at the time of deposing in the court.
But in chief, he says, my lord, X-ray shows fracture of left radius as per his report.
এই চিফৰ তাত কৈ দিব সি যে ডিপ'জ কৰিছিলে that as per X-ray, huh?
Next, madam, another
Yes.
sentence is important sentence.
Please
here.
take your seats. What transpires from the above is that the prosecution relies upon the testimony of the eyewitnesses, PW1, PW3, 2. 2 is not an eyewitness, no?
Who is the informant? Ma'am?
He did not
He
see.
is not the
3, 4, 5.
3, 4, 5.
In order to sustain the conviction of the accused petitioner. It appears that PW1 is the victim himself, and PW3, 4, and 5 are his brother and sister. eyewitnesses merely because is related cannot be branded as liars in toto. On the contrary, such testimony has to be evaluated carefully. Stop. The courts are required to be realistic in their exception from such witnesses. The test is whether it was possible for such eyewitnesses to be present at the place of occurrence, and is there anything inherently improbable and or unbelievable? Therefore, unless the testimony of such related eyewitnesses is shaken by glaring infirmities, the same is not required to be thrown away. Refer, exact case or citation detail. 1990, volume 3, SSC 266, 2013, volume 11, SSC 688. In the present case, it appears that the eyewitnesses have categorically narrated the manner in which the accused petitioner has inflicted the blow on the victim, PW1. Such narration of the eyewitnesses to the assault is also fully corroborated by the victim's own testimony. It further appears that the victim as well as the eyewitnesses have clearly deposed in the court consistently that the accused petitioner assaulted the victim in his which hand it was said? In his left hand with a X, with an X. The medical evidence fully corroborates the nature of the injury described by the eyewitnesses. There is nothing to doubt. Though it has been, though it has been brought to the notice of the court that there is evidence to indicate that there is a dispute going on between the families of the accused petitioner and the victim. However, the fact that on the date of the occurrence, when the accused victim was cleaning the drain in question, the accused petitioner came from behind and slashed him in his hand with an X is clearly established. it is clearly evident also from the evidence of the medical officer that in view of the injury inflicted by the accused petitioner, there was a fracture in the left hand of the in the left forearm of the victim PW1. Hence, the case categorically squarely falls under exception under list 7 of section 320 IPC.
Left radius. Exact word is left radius.
That's okay. It appears that both the trial court and the appellate court has clearly assessed and evaluated the materials available on record and has accordingly recorded a finding of guilt against the accused petitioner. Merely because the investigating officer was not examined and or the seized weapon was not produced in the court does not in the facts of the present case makes the prosecution case vitiated. The cases cited by the accused by the learned counsel appearing for the accused petitioner on this point are clearly distinguishable in facts. Likewise, for not examining another brother, i.e. Amrit, who is stated to by the PW1 to have been present at the time of the incident, the prosecution case is not vitiated inasmuch as the remaining brothers, the other brother and sisters of the accused, of the victim who has witnessed the incident were examined and has corroborated corroborated the case of the prosecution in material particulars, fully in material particulars. Hence, this court finds no illegality or infirmity having been committed by the trial court and the appellate court in convicting the accused petitioner. This is done under 326.
326.
But imprisonment for 10 years.
This 10 years.
Imprisonment for life or 10 years.
Life.
And here it is 1 year given.
Yes.
Na?
Yes.
Considering that the trial court as well as the appellate court has sentenced the petitioner under section 326 IPC for rigorous imprisonment,
Simple.
for simple imprisonment for 1 year jail term, this court finds the same not to be excessive or disproportionate in the facts and circumstances of the offense. That being so, the appeal fails. Yes, sorry, revision petition fails, sorry. And anything to be added?
Till surrender before SDGM Rongia within certain period, 1 month or.
In view of the aforesaid finding and observation, the accused petitioner shall surrender before the
SDGM Rongia.
SDGM Rangia
Rongia.
within
1 month.
1 month.
Because he may.
within 1 month from today. What about bail bond?
Bail bonds then cancel.
Resultantly, the bail bond stands cancelled.
Till then, it will remain. Till surrender.
No, till surrender or so and so weeks, whichever is
Earlier.
early, till then only. If you don't surrender, then
Till the period.
till so and so period for it, yes. है ना? The bail bonds, and after expiry of so and so period, the
Right,
bail
yes,
bonds
yes,
sell.
All right, you.
Sorry, Mr. Sharma.
I'm obliged.
Yes, apni job. It is side job, but yes, yes.
My lord.
11?
I had item number 4 today.
Ah.
Criminal appeal.
Ah.
I thought I came prepared to argue the matter. But for a second I missed it. I was sitting in court number.
That I think we have already given that.
Given that order on my. That's why I thought I'll do that item. And this one I'll do either next week or whenever Lord sees next.
Okay,
my lord.
this we'll do it again. If
Lord.
you have problem today, then we'll do it
My
another
lord,
day.
other lordship is sitting next week or
We'll do it another day. It's not a parted matter.
not part of
11, 12 and 13.
13, my lord.
Mr. Smith?
Hello.
11,
First week
12,
of, can it be first week of December, my lord?
11, 12 and 13 as prayed for by Mr. M. Nath, Learned Senior Counsel, assisted by Mr. A. Bhattacharjee, which is not objected by Mr. M. Nath, Learned Standing Counsel ESI, relist on such and such date.
M. Smith.
M. Smith, what did I say?
M.
Oh,
Okay, both the
I think by now I am also becoming very mechanical.
no.
Huh?
Very similar.
After dictating long judgments in court.
Oh, the previous judgment, quite, is that hectic, my lord? Quite hectic.
Very hectic. Anyway,
4 December, my lord. My lord, in the meantime, I just want to go to the records, my lord. Can I go to the records, my lord?
yes.
My
Item 14.
Yes.
May I please your lordship?
Where is the other side?
And I is
Hmm. That's why I'm asking, where is the other side? Heard Mr. R.A. Chaudhary,
Alam.
A. Alam, Learned Counsel for the petitioner, none appears for the respondent on call. The relist. Did you on such and such date? Mr. Mohanto and his juniors are generally there.
Yes.
So, yes.
Next.
Next. In fact, I saw Mr. Mohanto in the morning also. Inform them.
9.
Yes.
9. Item 15.
Yes. Where is the respondents? Heard MS
Begum.
R. Medi,
Begum.
R. Begum, Learned Counsel appearing for the petitioner, none appears for the respondent on call. Released on such and such date. Yes.
Obliged.
হৈ গ'ল? Which one was there? Time big. Why was this time big?
Actually, what happened, I was not present.
Oh, this is that matter.
Yes,
Yes, what happened to the notice?
Perhaps Lordship, no order for issuing notice was
Correct, why?
passed. It is
Electricity matter.
an order as for from the year of the year 2020.
14. But
Perhaps Lordship, the learned honorable court decided that
that has to be
respondent who is not-
reflected. Now there is no one, and this number 2 is who is he? He's the informant.
informant.
So there is a standing council of AACB.
ACB.
Can we have it in his presence?
Yes, ma'am.
Let us have it with his
Yes.
presence.
Yes.
Your name?
UB Sharma.
Heard, Mr.
UB Sharma.
UB Sharma, Learned Counsel appearing for the appellant. Also heard Mr. MP Goswami, Learned APP for the state respondent number 1. However, it appears that no notice has been issued for the respondent number 2 stroke informant. The noticing that the respondent number 2 informant is one officer, one vigilance officer of AACB, LAECDCL, Bichuli Bhavan, Guwahati 1. This court has requested Mr. MP Goswami so and so to inform one of the standing counsel of APDCL to be present on the next date of listing. List on such and such date, let registry reflect the standing counsel name of standing counsel APDCL in the cause list. In the meantime, let copies of the appeal memo be also furnished to the standing counsel APDCL. So we'll have it in his presence.
That may be kindly after 10th day of December. Helium.